Well, kids, you know, jazz hands, ladies and gentlemen. It is a Saturday. It is my birthday, and it is time to watch some court. Ladies and gentlemen, I am your lone wolf Uso. I have put together about 3.5 hours of court goodness ready for you. We are bookending this morning today with Judge Simpson and Judge Middleton. We're going to start off about 55 or so minutes of the first hour is going to be Judge Simpson dealing with a really crazy case from back on Tuesday. We are taking all of these cases today in order, ladies and gentlemen. So we're going to start on Tuesday. We're going to move to Wednesday, Thursday, and we're going to end with Judge Middleton's crazy 3-hour long docket yesterday. But we're not watching all 3 hours, just for the highlights. Just for the highlights. And ladies and gentlemen, Blackboard is live, and it all starts right now.
Court does call the case of Lori Peterson versus our money lines. State your names for the record, please.
Right. Our money one.
This is a landlord-tenant action. And this is for termination of tenancy. What's the basis for the termination of tenancy?
There's rent, late fees, utilities, court costs owed. And then there's exterior damages. So I'm asking for total definite request of $14,148.06.
Exterior damages.
I have photo documentation.
I understand that, but is there a lease to the premises?
I had a total of 13 exhibits.
I know you have sent a bunch of things in and court that it has to review them. They're absolutely out of context for me.
The lease is last exhibit. So that would be exhibit 1A. It's a lease agreement, and then
In which document? Is there a provision regarding the damages?
the damages, you see that in exhibit 9. I wrote out all the damages.
But you're relying upon a lease provision regarding those items. Which lease provision are you?
Yeah, lease provision. Okay, find it. Okay, with regard to the security camera that was installed, provision number 13, alterations. Tenants must not alter or modify the premises. Item number 8, occupancy. Only persons signs a lease are supposed to be occupying the property. Number 18, repairs due to tenant's negligence. Those are the items I have here. Damage to the premises caused by tenant's negligence or their guest, or it's really hard to read in here. It's dark. See item number 8. I can't read it. It's so dark in here. Damage to the premises caused by tenant's negligence, which are a total of $2,866. And I have printouts of that. Landlord's right of entry, number 19. She doesn't let me see the inside of the house. She doesn't even let me talk to her. Use of the premises.
Right, I got it.
Item number 6.
Ma'am, you can stop. Ms. Lyman, what is your position on this case?
I had an opening statement. I was going to say when I moved in on the 5th, which is after the 1st. So the first month rent should have been prorated. The calculation I did.
What month did you move in?
May. The calculation I did was 3,300 divided by 31 times 5. 533 off, $533 off. So that should be $2,767. In June, I paid an extra $200 in rent. I feel as that The court costs I should not be responsible for because we haven't come to court for no reason. I didn't fraud anything. I am who I say I am. I did a background check through Rent Spree. There are no damages. The screen door is on the checklist. She knew about the locks because prior to me getting renter's insurance, I told her I was getting ADT. I'm curious about her mentioning cameras because prior to me moving in, there was already cameras put up. I do not agree on the water bill. I believe they are drafted up by her.
That they were what?
Drafted up by her because water bills are supposed to come every 3 months. Back in July, she already had a price for a water bill in August, and the month haven't even started yet. After I didn't want a 3-year lease, that's when she started acting crazy. And she's been threatening and harassing me since and doing false police reports and calls.
You intending on calling as a witness to all of this? Miss Anderson?
Your Honor, I have, if you look at line item number 41 on the lease, it says that she started on the 5th. That's why it has rent is due on the 4th of each month.
That answering my question. Intending on calling as witness.
I just have witness statements, sir. I
What does that mean?
have witness statements in is it number 4? I have,
Yeah, but that's all hearsay.
I have photos of the damages.
Who took the photos?
I did of the outside. At the number 9. If you could bring it up on the,
No, I'm not going to do that. I'm trying to figure out, are you going to testify?
yeah, I can test.
Let's have her sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give me the truth, the whole truth?
Yes.
State your name.
Lori.
Go ahead. Tell the court what you want me to know.
It just don't exhibit over time. I don't know if she could pull it up on straight and color. But shows you're pretty well out. Look at the police report with 2.
Ma'am, you have 1A, 1B. These exhibits haven't been marked and admitted.
There's a lot of information because I've had a long time to put this together. Okay. Exhibit 2 is a police report where the child was going in and out and broke this. Exhibit 2.
Go ahead.
The police report.
Well, what I have is exhibit. What does it say at the top?
Police report with the number.
That is not what I have as 2.
Can you see these exhibits to see what the endings and
Show them to Miss Lyman, please.
thumb drives that I want back? Thumb drive.
Ma'am, how many sets of paperwork did you send in with numbers on them?
I sent each exhibit, like exhibit 1 and then exhibit 2 is the
Ma'am, I have 2 things marked as exhibit 1 from you. Well, and then 1A. This document you've given me has 9 on it.
That's the exhibit 9 is the pictures of the damages. Exhibit 2 is the police report. So the officer, they saw it was running in and out of the screen, in the police report. That screen was broken from in and out. Screen, you see, for an active screen doesn't look like that.
On page 2, I've got oil stains.
Yeah.
That's the damage you're claiming?
Yeah, there's oil stain damages. It's
And then
required special.
the-
They're from their junky cars that they had that I think the police had towed. Somebody had towed, but they had the junk cars in the driveway.
then I've got I don't even know.
Oil stains, that's where
What?
oil stains will require professional remediation, and that's going to cost $407. Get out of the driveway.
Where are these prices you keep coming up with coming
That's
from?
the estimate that I got from a licensed
I'm
contractor.
gonna have somebody testify about that.
I can get it done and bring a bill, or he just he's actually done work in the past, and I showed him pictures of driveway oil stains.
Well, I don't. Are they coming here to testify? I can't take hearsay.
How do I get him? Do I get it done and then bring the bill back to the court?
Man, I can't advise you on what you need to do, but
That's going to require.
stop talking. What is this usage history? Where'd this come from?
That's the usage history of water bill. She's the
Where did this graph come from?
from Pittsfield Township. When you go on the website for water usage, you can see where when I built a house and
I know how it works.
so I just estimated the water bills based on her daily usage rate.
So have you been billed for water that hasn't been paid?
I'm waiting on.
That's a simple question. Have you been billed for water that hasn't been paid?
Yes,
How much is that bill?
that was May for May. May water, it was $207.29.
I thought some of these aren't even this resident.
What, that's the other house that, Armani, or she lived in my house, sir. That she caused, extensive damage on.
So what does that have to do with the damage to this house?
It was just showing it similar damages that are starting to occur, and I'm worried about my property, worried about what could happen to it.
These are all mixed in with this property.
The main things, sir, that you could see is driveway oil stains, your screen door, the 2-inch custom wood lines that she runs. You could see that in the picture, and she acknowledges that.
Why do I have a Court of Appeals case?
That's the case that's the house. Remember, I was coming here for fraud because she said she lived at 990 Arlington, and in fact lived at this other place. The place was actually being evicted, and I didn't know, and that's why I had this thing with fraud that I wanted to read to the court.
No.
It's case law. I have a summary of a case law that shows somebody commits fraud that.
Ma'am, you're alleging that they committed fraud. You have to prove that to the court.
Sir, she already admitted in the previous trial in 99 in Arlington. She was living at
Do I have a transcript of that?
that trial. That was, I mean, I can get a transcript.
What relevance is that? Are you claiming here that she's not living here?
I'm claiming that the whole thing started because of fraud. She claimed that she lived at one residence that she didn't. She was actually being evicted at another residence, and she caused over $75,000 worth of damage. And that's why I'm concerned. She left the water running, and I'm concerned about my property. If she does that to my property, I'm going to be ruined.
Which ones of these photos are this current residence and which ones are the other residents?
Did they not email? Because I asked them to put this up on the screen. These pictures so you can see my color. I asked the court clerk, sir. I mean, I can show you, sir, the damages.
If you're claiming that she committed damage to the premises, you need to show me that. What I got is a package of stuff that you labeled 9, which includes water bills, includes stuff about other residents, face sheets from court of appeals cases. It's just a mess.
Sir, I emailed the clerk and she said I could put on the screen. Could you pull it up? Maybe we could see it.
It's not here to do your job. If you want something broadcast on the screen, what is it?
Can I show you may I approach the bench to show you?
No.
It shows the damages that I have there. The oil in the drive sink.
I see the oil on the drive.
Screen door that's ripped out. The custom wood blinds, you can see that in the picture. I have a circle around. The locks were changed on the front door, and I didn't authorize that, and that's in the lease that she's not supposed to change the locks on the door. Basement.
What if she changes the locks and then changes them back upon her move out?
Well, the problem is the other house, she changed the locks and then she let the water running for a month and did over $75,000 worth of damage. What if she does that to my house?
Ma'am, I don't know. What if she does it to your house? Has she done that to your house?
I don't want her to. That's what I'm afraid of. I feel like I need to have access to the property for emergencies. That's why I have it in the lease. I don't want her to damage the property. This is my
Changing the locks on the premises, ma'am.
Yes, I have a Yale lock from ADT.
Let me ask you this. Will you allow her to inspect the premise?
She came in July 21st and inspected the premises.
Did she go inside?
Yes, I let her in. Well, first, I was in a meeting, so I didn't go to the door right away. When I went to the door, she ended up calling the police. So I closed the door, let her wait on the police. The police came. She asked, could the police come in? I told her no, because there was no reason for them to be. She was mad that I still wasn't in with her.
Okay. I don't know why neither of you want to answer my question. Did she go inside the house?
Mhm.
Yes.
Did you go inside the house?
I was not allowed in the basement or in the garage or in the master bedroom closet. And in fact, there's a picture there.
So everything other than those 3 areas, you were in the premises.
Right. And there's a crack in the basement, sir, that has to be fixed before winter because there's water leaking in and I can't even get it fixed. She won't let me in.
You know what crack she's talking about in the basement, ma'am?
Yeah, it's a crack in the basement where there's no insulation. It's supposed to be a spot open for the crack in the basement.
Your what?
It's a crack in the basement. The panel of insulation is moved off that crack so you can see the crack in it.
Can I show you that in the picture?
No. You told me that she hasn't allowed you access to the premises. She has.
No, but I only got a picture of the basement because I went outside and took a picture of the basement through the window. And I have a picture showing the insulation is all torn down.
How many rooms are in this house?
Probably 15, but she damaged the insulation in the basement.
Did I ask that? You went into the premises. You listed out 3 spaces that you say you weren't allowed into. All of the others she allowed you to look at?
Yes, sir.
And so it's the basement?
The basement, the reason why I need access to the basement is because there's some crap that I need to get.
You didn't ask why.
Yes, sir. The basement,
It's the basement?
basement and garage, and was not. That's all. Pause.
Master bedroom, basement, master bedroom closet, basement, and what else?
Garage.
Did she not have access to those, ma'am?
And we was on the time stretch because she wanted to wait outside for the police.
What now?
It was on the time crunch. I had to be at class and she wanted to wait half an hour for the police, so she didn't get to look at it.
Yes.
There's a crack in the basement that I need to have repaired, so I need to take a photo and have the repairman go in. Also, the insulation has been torn down. That's going to cost about $500 to put it back up. That's part of the damage.
Did I ask that?
Sorry, sir.
So when can she get into, was there a reason why she wasn't? Yes. Is the reason why she wasn't allowed into these areas because of that? Because of the time crunch?
Yeah, I had to go to school.
Can I also be allowed to take photos of damages? I mean, I don't know if she still wants to stay there or if she wants to move. She hasn't talked to me, so I don't know.
Just keep talking. When can she come in and look at these other places?
Wednesday is the 17th.
The 17th? She needs to get in before then.
Or then
Otherwise, I'm going to order a date.
Wednesday the 10th.
That's a week out. If I order that it occurs this Friday, what are you going to do? You're going to have somebody else there to let her in.
Sure. I really don't see the reason for her to look in my closet or in the garage, but I literally can send her a crack of the crack in the basement.
Inspection on September 8th, 2025. You prefer afternoon or morning, ma'am?
Afternoon.
Yes.
I'd be allowed to take photos. She wouldn't allow me to take photos last time. Damages, any damages I see?
I only worry about that only because you don't seem to know boundaries very well, Miss Anderson. But I will allow you to take photos. The inspection will occur September 8th, 1 p.m. It is to last no longer than 90 minutes. Right now, I don't necessarily, was there a security deposit paid?
Yes, but I I need to know, does she want to stay or does she want to work things out? I don't know. She's not.
Paying rent into escrow, I'm presuming she wants to stay.
Yes.
Yes, she has.
She didn't pay August. She just paid July.
She has paid rent into court escrow. Since the time I ordered it, she paid August and she paid September.
I just called the court and they on Friday.
Miss Whiteling? Yeah.
She's calling.
Give me the date she's paid for escrow, please.
August 1st is the first date and September 2nd is the second date.
When she paid $3,300 in escrow each time?
Each time, yes.
Okay, she's paid escrow.
She just paid because I didn't know. I called on Friday and she had.
I don't, but they would have told you she paid August. You said she didn't pay August. She paid August.
No, Friday she didn't pay August. She just paid August. When I called them, they said that she hadn't paid August.
There's one on August.
August 1st.
No, that's July's rent. She was late on July's rent.
Okay, I don't really care what you call it. She's paid 2 months in escrow.
Yeah, she had to pay.
I don't care what months. Man. You told me she hasn't paid escrow, and she has.
She didn't pay it last week when I checked. So if she paid it this week, I didn't. She just.
Last week, September would not have been due. I
no.
ordered escrow. I don't, ma'am. I ordered her to pay escrow in the court. Told her she needed to pay for August. She paid August rent, August 1st. To the court escrow.
Sir, that was July rent. August 1st rent was July. She was late on July rent. When she paid August 1st, that was July rent. She just must have just paid August rent today or a couple, she just. I call the court every day and they say, no, she hasn't paid. She hasn't paid.
What did I just say? She has paid 2 months' rent into escrow. You tried to claim she hasn't paid any rent into escrow.
Oh.
She has indeed. She's deposited $6,600 into court escrow.
Can that be released to me, sir?
No. Not while the litigation's pending. I'll make a decision on that at some other point.
And we put water in escrow, the water bill.
I'm going to do that. I mean, it seems to me that with her, and I don't know what the deal is, you just keep trying to take these preemptory strikes. You came in here initially saying she wasn't the person that was renting the premises. She's the only person that I've seen. And you also said
Or I was talking.
also do not enter.
Right.
You also accused her of not being the person that you dealt with. She's been here every time. And you said that to the court, and she was there when you went through the premises. So I'm unclear as to how this isn't the person and what fraud you're trying to claim she's committing. Yeah.
The fraud was on the application. She said she was living at 1990 Arlington, and in fact, she was living on Maplehurst. So that's the fraud she committed. And in fact, I have case law that says that if that fraud is used to, I can read it here. It says, I studied the case law for this. It says, Fraud based on false representation. A person commits fraud by knowingly making a false statement regarding a material fact with the intent.
Ma'am, I know the law very well.
But she committed fraud on the application.
Ma'am, you have not shown me that she's committed anything at this point.
She lied on her application.
So is your conclusion, but you have not shown me anything. Ms. Anderson, let's make one thing real clear. I'm going to have this trial at some point, but just because you say something does not make it true. You have to prove it to the, do not raise your hand, I'm talking. Until such time as you prove it to the court, it's nothing. And just because you say it's true doesn't make it true. And that's the way this court is going to operate. Yes, now you may speak.
I submitted video evidence, in fact, 2 thumb drives I'd like returned to me, but it was.
Ma'am, you submitted those to the court. They're not going to be returned to you. I have not even had the trial. Why would I return them to you? I don't even know why you gave them to us, first of all.
Because
But
to give you video evidence, I needed to put it on. That's what.
yes. But why would they be returned?
Because I have personal files on it. They didn't tell me that they were.
For Pete's sake.
They didn't tell me that she said I would get them back. I didn't. That one thing cost over $100. I was just.
Ma'am, you may get them back at the conclusion of this case, but the way this is going, I don't know when that's going to be.
If she wants to live there, I'm happy with her living there. I just want to have some rules followed. That's all. That's all I'm asking.
What rules do you want to follow? What?
Just fix the damages. Sir, I don't mind her living there. Just fix the damages that she's caused. I'm in for financial hardship because I can't even pay the taxes that are coming due because I'm not getting any money because it's an escrow. I can't pay my property taxes in September. I have no job. What am I supposed to do, sir? Get on the street with a tin can? I don't know what to do. I mean, I'm in financial distress.
If you want her to stay there, then stay there. Maybe you should talk to her instead of just accusing her of everything.
To me, I tried to talk to her. Why can't we just fix the problems, fix the driveway, fix the blinds? I'm the one struggling financially.
Ma'am, I don't know that those exist.
Sir, I can point them out on the pictures.
How much of a security deposit did you post?
Huh?
How much of a security deposit did you post?
Let's see.
It was 6,000.
5,250. I don't have to pay my property taxes. You want me to cry? Because I'll cry. I don't know what to do.
Ma'am, you can cry if you want to. I don't know what you want me to do. Just because you cry doesn't mean you get your way. Doesn't work that way.
How do I pay my property taxes?
I don't know, ma'am. I really don't.
I could lose the house.
Here's what I'm going to do. There's going to be an inspection of the premises on September 8th, 1 p.m. That's for a maximum period of 90 minutes. Plaintiff will be entitled to take photographs of the premises, but it should not last longer than that. I would suggest, Ms. Lyman, that you may want to record and or take pictures yourself. I would also indicate that whatever it is being submitted on this paperwork, the exhibits must be submitted to the court. I want on each exhibit is to contain just one subject matter. This whole flurry of papers all stapled together about 8 different things isn't going to work. So it's going to be one subject matter per page or per exhibit if it's a multiple type of thing. And then they are to be single-sided. So if it's about the water bill, that's its own exhibit. If it's about the oil stain, that's its own exhibit. If it's about the balcony railing or ledge balcony railing, then that's another exhibit. If it's about the camera, that's the exhibit. I would further indicate to you that all right. And then I'll adjourn this trial to September 29th at 9 a.m. Any questions from the plaintiff?
I'm in financial hardship. Is there any way to like have this to a conclusion? Because I can't even pay the property taxes that are due September 18th if I don't get any rent money. I'm struggling. I have no, I'm struggling. Can't you have any pity of it? How do I pay?
Ma'am, I don't know what you want me to do. You don't win just because you have financial hardship.
I know, but getting the rent is just part of paying the property taxes. If I have the rent, then I get the property tax. That's all, sir. I mean,
You brought her here for not paying rent.
okay. I just want this. I want to come to a conclusion. If she wants to stay,
Well, did you talk to her about it?
I want to come to a conclusion. I just want to get the repairs done. She can live there happily, and I can be happy.
Okay, if she doesn't do the repairs, what are you going to do?
Maybe she will do the repairs.
But if she doesn't do the repairs, what are you going to do? I mean, part of the reason you have security deposit is to protect yourself from damages and other things.
Well, so you're saying just let the repairs go for now, and then
Ma'am, I have not said anything. You're the one that keeps talking, saying you want the repairs done.
well, at least if we can do the rent and the water and those late fees, and that's that at least help me pay the property taxes. The crack in the basement, I have to get that repaired. That's my responsibility. But I need a photo to get the guy out there to fix it. I'm willing to work with Miss Lyman together.
Ms. Lyman, are you willing to work with her at all?
I've been working with her the whole time. What's wrong with her? She had a picture of the grass.
But they're going to need a better picture because they're going to have to give me an estimate before they come out to repair it. So when I go on the 8th, I can take a better picture inside of the crack. If she'll talk to me on the phone, we can work together. I don't have a problem with that. Either time.
I have a feeling that doesn't work. That's my feeling.
I want it to work.
Well, sometimes, Miss Anderson, the important thing in trying to work something out is you have to listen as well as just talk.
Maybe after this hurt, I can talk. I'm willing to work things out.
How about you guys go do this? Give you half an hour till 4:05. Go out, sit in one of the conference rooms, try to work out what you can. Because if you want it to work out, that's fine. But, otherwise I'm going to have a trial.
Okay, we can talk. Let's talk.
So you get half an hour. Go out there and talk. I mean, listen to each other, talk to each other. I don't know what she's gonna do, but even if in terms of the escrow money, just so that you know, you guys can do anything, agree to do anything you want, except that escrow money, I'm in control of it now. So it's not being paid out, so don't even ask about it. Ask about what the issues are, what you want her to do. But she's a tenant. She's not at your beck and call. Court's in recess. Back on the record in the case of Anderson versus Lyman. All right, you guys get anywhere?
I think we got somewhere.
Yeah, you want to tell me what you guys did?
I told her I was willing to just accept the rent, and I should be getting the actual water bill for June, July, August, this week. Pittsville Township will usually get it out this week for those. She said she's willing to pay that. And she said that the compromise is she would pay the main water bill of $207.29, and I would eat the court costs myself. I wouldn't charge her that. I thought that was a good compromise. And then we worry about repairs later. And I would let her keep the camera, the door locks, and she would give me periodic access. Like, we could try to see the house maybe once every 3 months or something, just to feel comfortable.
Yes, ma'am.
Okay. So we did talk about the 3 water bill thing. She did say that all the prices that she had before were estimates. And then that when she gets the real deal, she'll show me that so I can actually see that it's real. We talked about the inspection, and she said if I can just show her a picture of the crack, then we can just meet in the middle and won't have to physically have an inspection. And
If what for the basement wall?
yes, if I can just send her a picture,
Okay.
you won't have to worry about the inspection. Next Monday?
Yeah, because I got to get that repaired before winter. So the picture will help me get the contractor out there.
Okay, and you can get that over to her? Yes?
Yes.
Ma'am in the back, what is your name? Okay, let me just explain something. You two were texting each other during the court proceeding? Not tolerated. Okay, so if you have to come back, ma'am, you're not going to be entitled to have your phone with you.
No, I was reading from my notes.
Ma'am, that's not what was happening. Okay, so who's going to write this up as to what you guys agree? What is this going to do? The case is going to be dismissed?
That's like I should be able to defend my name.
I just want this to be over, sir. I mean, personally, I just try to get along and work it out with Miss Lyman. If she could I told her that she could keep the locks if she could give me periodic access to look at the property. She could keep the camera, all the things I was complaining about. I'm willing to negotiate, compromise.
Ms. Lyman, what did you were trying to do what now?
Just showing that there's no damages. That's what I have for the pictures. In the inside of the wall.
Okay, then here's what we'll do. We'll cancel the inspection on the 8th. You'll send a picture. Okay. And then you guys work out however you're going to work it out, all of the details. And then we'll reconvene on the 29th and come up with. Because I don't know. I mean, I'm not sure what you want to have happen.
Just trying to clear my name on everything that. Hold on. It's pretty much
Clear your name on. Go ahead. What were you saying?
talking about all the false statements and stuff like that.
The exterior damage.
Just
Well, you accused her of committing fraud. And I think that's what worries.
Well, that was just about the prior address, which I still don't doubt, but at this point, I'm willing to let that go if it'll just let us move forward. I just want to move forward. I don't want to keep on hashing this out.
Okay, I get that. But you understand, you accuse somebody of that. And then what I think, and Ms. Lyman, correct me if I'm wrong, but it seems to be she wants her name cleared. That's a serious accusation that you've made that she's committing some type of fraud.
For the address?
You accuse her of fraud on a number. But you guys do this. We'll reconvene on the 29th. I'll still leave it set for the trial. Figure out what you two want. If you guys could draft up some type of an agreement as to what you're going to do in terms of the periodic inspections and the like, but that would have to be part of whatever agreement there are, especially also you're going to pay the water bill, but you're also going to eat the cost of the filing of this case.
Her to pay May water bill?
she kept telling me that the water bills are estimated. So I want to see that it's actually a real water bill.
Go ahead, yes.
Okay, this is the deal. May is higher because the May is an estimate, but the June, July, August will all be actual. So I asked her, I said, given that May is an estimate of $207.29, would you be willing to pay that? And then I will eat the court costs of $183.59. I thought that was a fair compromise. And I thought she agreed to that.
She was in. But the May bill only includes water usage during the month of May?
Yeah, 27 days. And that was an estimate. And that's why I said, okay, I admit that's an estimate because it's done every 3 months. If you would be willing to accept the estimate.
Why is that estimated?
Well, because the water usage went from 207 a day to 768 a day, meaning she used 3 times the amount of water. So we get a water bill every 3 months.
I know how that works, but why is it estimated?
Because it's the water bill, instead of being divided in a third for that month of May, a third, it's higher because her usage rate is higher than my average usage rate. So I based it on the last year of my daily usage rate, which was about $2.36 a day. You know, I sent you an Excel spreadsheet. I know but so her water usage rate is higher than mine. So I had to estimate her water bill for May. I couldn't just cut it in a third. So, I mean, if I cut it in a third, will she be willing to pay the court costs? I mean, I'm willing to negotiate, work something out. If she pays the court costs, I'll just cut the May bill in a third. I think whatever she wants.
Well, who was there before she moved in?
That was me. That was me and my client. Me.
Then
So for June and July, those 3 months, 2 of the 3 months were me. And then she was the third month. So would you be okay with me just giving you a third of the third of the last water bill and then paying the court costs? Either way, I want to work this out.
how much is the water bill?
But she keeps saying it's estimate. So I don't know the actual cost.
The last water bill that I paid was $334.92.
Basically 335.
Yes. That's for 3 months.
What 3 months?
March, April, May. March, April, May. And then she was there 27 days of May. March, April, May. Yeah, it's every 3 months. Yeah, it says March 1st through May 31st, bill was $335.
So it's not really an estimated bill. It's actual water usage. Does it break it down by what you use?
No, it just gives you, so basically I have to charge her for, I got to estimate her May usage. So I estimated my usage $2.03 a day and her uses as $7.68 a day. Whatever's fair, Judge. I just want to be fair. Whatever you think it's fair for that May water.
Is that through Yucca or the township?
Yes, sir. Or it's through Pittsfield Township. I have.
They should. I thought you could get a monthly bill. They just don't send it to you except every 3 months.
Yeah. I pay at least 3 months. I don't know what the month.
No, I get that, but that most jurisdictions do that. They send out a bill and it's a 3-month bill. The question becomes whether or not they can tell you what the actual usage during the month was in the month of May.
I mean, I can try to ask. I haven't asked. I'll try, sir.
I mean, because that's what I think Miss Lyman, and correct me if I'm wrong, Miss Lyman, she would like, if you can get the actual usage and get the actual usage, and she'll pay it, right?
Yes.
Okay.
So I'll take that as an assignment.
What I would suggest is you guys get together, work out your entire deal, come on the 29th, and then we can sort of formalize what it is. Yes, ma'am.
I just wanted it to be noted that I paid the $52.50 plus the $750 cleaning fee, which would be $6,000.
Say again.
I just wanted it to be noted that I paid $52.50 plus the $750 cleaning fee, and I just wanted that to be noted. So it'd be $6,000.
Well, but there's a non-refundable cleaning fee.
She said that I could get it back.
Yeah, I remember, Judge, I said that if she keeps it clean, I told her verbally that if it's left in the same condition, I gave.
What's the lease say?
The lease says it's non-refundable, sir.
Yeah.
But I gave her my verbal.
Okay. That's fine. So, how much was your security deposit, Ms. Lyman?
$52.50 plus the $750 cleaning fee. $6,000.
You said 5250. So, what's the extra amount on security deposit?
300. That was because originally the lease was the house was rented out. I had 3,500 on. I gave her a $200 discount because she wanted to be one occupant. So I felt like, that's why I lowered the rent to.
Okay.
That's what that was. Originally it was 35. I gave her a discount.
I don't know how you're going to work it all out, but I'll just say this. Your security deposit can only be 1 1/2 times the monthly rent. the security deposit that you now hold is in excess of that.
Yeah, well, sorry, I guess I originally was based on 3,500, so that's why it was based on 3,500.
I understand where you got the number. What I'm telling you though is that the security deposit can only be 1.5 times per month, a monthly rent. So somehow or another, that additional 3, I guess it would need to get back to her because that's a tenant's money, but you can't hold that 300.
So should I just add in the agreement or what do you want us to do?
Well, something's going to have to be put in. That's an illegal security deposit. And it's the tenant's money until such time as they vacate the premises. So. Put it all together. You guys agree on as much as you can. I don't mind trying to work it through with you in terms of doing it, but and then we'll just reduce it to writing and then we'll get this thing done with 29. Okay?
Sir.
Keep.
Mr. Black, can you come on the Zoom call?
Yeah, can you hear me?
I can.
Okay.
So this is on for pre-trial. So you don't have an attorney, is that correct?
I'm not sure I need one yet.
Okay.
Can I have your name? It says DC.
Your Honor, if I may, a couple of things.
Yeah.
First of all, the state has received a supplemental report and is prepared to establish probable cause at this time. And then also, if the defendant is electing to go pro se, the state would request a pro se colloquy.
Okay, I think that may have already happened. But in any case, so Mr. Black, right now, this is on for a pre-trial, which is the opportunity for you and the state to discuss the case or maybe come to some sort of resolution. And then it can be, and right now it's set for trial. Otherwise, it would continue on to trial. Your trial confirmation is October 22nd. And then the trial itself would be October 29th and 30th. So I guess where do you said you don't think you need one, but which tells me that you don't have one at the moment. So I guess how do you see this case progressing and playing out?
Can I have your full name and the prosecutor's full name?
My name is Sam Meyer, and the prosecutor's name is Ms. Kidmacher.
Is it Meyer?
Yes.
And the prosecutor's name again is
Last name is Kidmacher.
okay. And first name?
It's Gabby.
Okay. And can I see your oaths of office and official bonding information?
Well, again, speaking only for myself, the answer to that is no. I don't have it on me. I don't carry around with me. I haven't. It's not necessary for me to post my bond. And, the person who needs to, I'd like to know some information from you as to where you see this case headed.
When the officer stopped me, if I were to tell him that I have a license, I have insurance, I just don't have it with me, I don't think that would cut it with him. It's important for a driver to have his license and insurance in order because operating a motor vehicle is a potentially hazardous occupation. The same is true with being a judge or a prosecutor. It's a potentially hazardous occupation because people could get hurt. They could go to jail unlawfully if something goes wrong. So a judge needs an oath of office, which is anomalous to a driver's license. And
Right.
the bond is equal to the insurance that a driver would need to have.
So I do have a oath of office. It's good. The auditor's office, if you want to go there and get it, you can certainly look at it. But you know, like I say, I don't carry it with me. I don't have it on the I don't have it posted on the wall. I don't believe I'm required to. You are required to have a driver's license when you drive a car. But I don't, you know, we're going down a rabbit hole, which really isn't that productive for you, Mr. Blatt. I'm trying to figure out, you know, where you see this case headed. And it's either going to be set for trial or there's going to be some sort of resolution. And if you think you've identified some issues with me or you haven't seen my oath of office, if that's an issue on appeal you want to raise, if you get convicted, you can certainly do that. But we're not going to spend a lot of time on, you know, things that don't really matter with regard to your case. You might not believe that it doesn't matter, but it really doesn't. Right now, you're the one charged with driving with license suspended in the 3rd degree. Your options are go forward to trial, which I've told you when that's scheduled on October 22nd for trial confirmation on October 29th and 30th. And that's kind of, you know, so I guess I'd like some answers from you as to where you see this case headed.
Okay, you just said you don't want to spend a lot of time, but if the prosecutor wants to spend 3 months of my time in a jail, then you have to afford me the time I need to get due process. Now,
Yeah.
at the beginning of this Zoom hearing, I heard you say that the state is charging me, but the paperwork I've been giving says the city of Tumwater is charging me. Could we clarify that?
Yeah, I can clarify that. And that was the mistake on my part. You are correct. It is the city of Tumwater.
But the city of Tumwater is franchised by the state of Washington, right? And it's using Washington statutes to prosecute this case, right?
You know, I don't know about the franchise aspect of it, but it is a municipal court case from the city of Tumwater. A lot of times municipalities incorporate on criminal codes and misdemeanors, they'll incorporate the revised code of Washington into their municipality with the law within that municipality. So yes, it could very well be prosecuted under a statute from the revised code of Washington.
Well, that raises some concerns with me because I see to your left, you have the plaintiff's flag behind you. And so are you a neutral entity or are you part of the prosecution?
Yes, I'm a neutral entity. I like to think that, yes.
Then why do you have the prosecution's flag behind you?
It's not the prosecution's flag. It's the flag for there's a flag from the United States of America. There's a flag from the Washington state, and then there's a flag for the county. I am a Thurston County District Court judge. I elected and have jurisdiction within this county.
But the state of Washington enfranchises the city of Tumwater to prosecute people under its statutes, the state statutes. So
I don't agree with your terminology there in terms of what they franchise. So Tumwater is a municipality. They have some discretion as to how they can choose to enforce laws within their municipality. One of the ways they can do that, and they're not alone in this, a lot of cities do this. Not everybody. Lacey, for example, has their own municipal code, but Tumwater might not. They might adopt the RCW for things like driving with license suspended in the 3rd degree, DUI, and misdemeanor and gross misdemeanor things and things of that sort. Of course, felonies, that obviously would be under the revised code of Washington, and that would go to Superior Court. But this is limited jurisdiction, and we only deal with misdemeanors and gross misdemeanors. We're contracted to provide court services for certain municipalities within Thurston County, including Tumwater, Lacey, and to name a couple, and that's why you're here. That's how you're here.
are you going to be the judge throughout all the hearings in this process?
I don't know. No, we have a rotating schedule and may or may not. I'm just the lucky one today.
Oh, this is going to put a burden on me to check all the judges' oaths of office and so on.
No, it's not. And don't worry about that. Like I say, our oaths of office are on file, and you can go look at any of them anytime you want.
Okay, I've been given this paper by the court. It says criminal traffic.
Yes.
I'm very upset
Yes.
about being called a criminal. I'm not a criminal, and I want to clear my name. Believe me.
Well, you haven't been convicted of this charge yet, but driving with license suspended in the 3rd degree is a criminal charge. It's a simple misdemeanor. It carries with it a maximum penalty of 90 days in jail and $1,000 fine. As a practical matter, would be highly unusual for anybody to receive that sort of jail time for a charge of this sort. But driving with license suspended is a criminal offense. It just is, and that was done by the legislature. And
Now, driving and traffic are commercial terms. I mean, you could check it in Black's Law Dictionary. And the police narrative says that I had a passenger in the car. Passenger is also a commercial term. And passenger, according to Black's Law Dictionary and extensive case law, says that it's a customer who pays you to transport him, which is basically trafficking. There's nothing in the police narrative that says that to support the presumption that I was engaged in any commerce or traffic. So the case should be dismissed on that basis.
No, that doesn't matter. If you get behind the wheel and drive a car, you need a license. And there are certain rules and there are certain things happen that can cause that license to get suspended. If it gets suspended and you get caught behind the wheel driving and the state can prove it, then you would be found guilty. Those terms of, Black Law Dictionary, whether they call that a passenger or not, I'm not really sure, but the law that applies in this case, like I've told you before, is the Revised Code of Washington, which deals with licensing and when people can drive and when they're eligible to drive. So all those things you say about, and again, you might not believe me, but those things you talk about, whether it's a passenger, whether it's a commercial term, none of that matters. The only thing that matters is, were you driving and were you validly licensed, or was your license suspended? And that's it. That's what this case is about.
Sir, I was traveling, not driving. Driving is a commercial term.
Okay.
At the time, I know anything I say can be used against me in court. I'm fully aware of that.
So hang on just a second. Well, it can, but you shouldn't admit that. If by traveling you were in an automobile and conducting that by having an engine running and applying pressure to the gas and brake and turning the wheel, whether it's traveling or driving, that's kind of like, 6 of one, half dozen of the other.
Sir, I need to make something very clear at the very outset. I'm not going to deny that I was traveling in my private property automobile on the date in question. I'm not going to argue. I'm not going to fight with the prosecutor about what the prosecutor wants to fight about at trial. My defense is going to be something completely different. Now, I noticed something on the website for the court. It says jury instructions or jury guide.
Okay, so hang on just a minute. Before we get there, can I take that to mean then that you wish to go to trial on this?
I wish to be left alone.
Okay, well, that's what everybody wants. But right now, where you are is you're charged with the crime of driving with license suspended in the 3rd degree. So again, I've went back to this before. Your options are either come to some sort of resolution with the city, or you're entitled to a jury trial. And then if you win, and you started mentioning, I want to stop you when you started saying things about jury instructions. And that means if you wish to go to trial, you can do that. And we can have a different conversation about your ability to represent yourself, which you certainly have a right to do, but I need to create a record that you're doing that, knowingly and voluntarily with open eyes. The possibility is still in place to have an attorney appointed to represent you, but when we started this conversation, I'm not sure that I need one. Most people, when they're charged with any sort of criminal offense, and again, this is a criminal offense, they take advantage of when they're offered an attorney at little or no cost. But again, that's entirely up to you. But what I need from you is a decision point on how you want to handle this case. Either come to a resolution or go to trial. And if you go to trial, then we're gonna, which is fine. Trial dates are set, but we're gonna have a conversation about a few things before we get to a jury instructions. So again, I need some input from you as to what you wish to do.
I only participate in fair trials, and I have concerns about whether I can get a fair trial in this court. Can I?
Okay. Well, the trial, if it's a jury trial, the people who are going to determine your guilt or innocence will be 6 jurors who will be impaneled from the jury rules within the county, and it'll be up to them.
there'll be 6 jurors and an alternate juror, right? So that's 7,
Yeah,
right?
typically, yes.
Well, this jury guide that you have on the website says that it's the juror's job to listen to all the evidence at trial, and the judges to deal with legal issues, not the jury.
That's true.
That concerns me about whether I can get a fair trial, because the whole purpose of a trial by jury is to consider issues of law. Otherwise, why do we need a jury? Because I've already stated I did the act. I traveled in my automobile on the date in question. I'm not going to deny that. That's the first thing I would tell the jury if it goes to trial.
Okay.
And I'm going to bring up to the jury the issues of law. My question to the court is how would
here in a second, I'm going to stop you for a second. You're very wrong about something. Okay, you are very wrong about something. The jury does not decide issues of law. The judge does. The jury decides issues of fact. The jury decides what did happen or not happen. That's what the jury decides. The jury's the fact finder. The judge decides what law the jury listens to. And that's just the way it is. And so when you say the jury decides the law, that's not correct. That's, there's no court in the country that where the jury, in this country anyway, where the jury decides what the law is. The judge decides what the law is. And you can look at any court in any state, in any jurisdiction in the union, and that's the way it is. And so the judge, and then the judge will, following the trial, following the evidence portion of the trial, the judge will instruct the jury on what the law is, and then the jury determines whether or not that person, you, did or did not do what you're being charged with. That's a fact inquiry. And what you're being charged with is driving with license suspended in the 3rd degree, and the jury's going to decide, did this happen or did it not? And if you have issues with the law, they're not fair, you might think this is unconstitutional. I've heard many times people think that, it's not constitutional for a state to require people to get licenses. It is. I've heard that, that there's some, the right to travel is being impinged by the requirements of a license. It's not. All of those things have been looked at by courts much above me, have decided that that's what the law is. And any instruction you're going to get on the law, or the jury's going to get from the law, has all been vetted in front of, courts of appeals and the Washington State Supreme Court, and that's the way it is. But you need to be clear. The jury does not and will not decide the law. The judge will determine that. And what I was going to say to you in advance of that is, you might not get to present. Maybe this is why you think you don't get a fair trial. Some of these legal issues you wish to argue, you might not be able to do that. Probably not, because that's just what the law is. And I know what the law is based on my experience. And I may or may not be the trial judge if it goes that far, but I just know that to be the case. So we're going to stop here for a second because but don't leave, because it's at 2:30. And we have some other people coming on at 2:30. We're going to take care of those cases, and then I'll come back and speak with you some more. All right?
I understand you believe all that nonsense, but I'm going to have a trial by jury, not a jury trial. A jury trial is 6 people that only consider the facts, and basically juries have been neutered since the rules of evidence have been implemented in the 1936. But this jury is going to hear the law as well as the facts, and I'm just curious. I would like to know how the judge would, how the court would stop me from communicating with the jury.
Well, that's a good question. I guess you'll find out if you take this to trial. But we're going to stop for a minute. I'm going to there's a couple people who we're going to take these cases, and then we'll come back to you. But don't leave. Okay, so Mr. Blatt, I'll come back to you. So I think when last we talked, you said you wanted a trial by jury or a jury trial. To me, again, that's...
No, I did not say that. I want to be left alone. That's what I said.
Okay. Well, again, that's what everybody wants. So do I. But nonetheless, where you're at right now, you're charged with driving with license suspended in the 3rd degree. And you had made the distinction, I think you had, and correct me if I'm wrong, I don't mean to misstate things. You were making a distinction between jury trial and trial by jury. And I'm not sure exactly what you meant by that.
Well, a trial by jury, which is what we used to have before the passage of the 19th Amendment, when women got the right to vote and therefore got the right to sit on juries. Juries had the right to investigate the crime scene, to consider the law, to nullify. Basically, it was a trial by jury. Now it's a jury trial where the jury's neutered. There's only 6 of them. They're cut in half, and they're not allowed to. They're scurried out of the courtroom every time there's important adult issues to consider, like children, and that's just nothing. That's not a trial by jury. But anyway, I have a dispositive motion right now that might settle everything here.
Okay, we'll set that for a motion hearing, though. We do those on Monday morning. Did you file it in writing?
I'd like to do that. I prefer everything to be in writing. So can we schedule a motions hearing?
We certainly can. But before we do that, I want to talk to you about, it again appears to me, well, we're going to do a couple of things. First of all, I am going to find, based on, there's a police report filed in sector. Based on that, I'm going to find that probable cause exists. And then we're going to set conditions of release, which basically are make all your court dates, don't drive without license or insurance, and don't have any other criminal law violations. Based on our conversation thus far, it appears to me that you wish to represent yourself at trial. Is that true?
I don't understand that terminology. I am myself, so why would I want to represent myself? Only corporations need to be represented because they can't speak for themselves in court. I'm not a corporation. I'm a human being.
So you wish to proceed to trial without a lawyer?
No, I wish to be left alone. That's my only wish.
But yeah, that's true. But that's one that's not going to happen in terms of this case. It is set for trial. The trial will take place. And my question to you is, you have the right to have a lawyer with you during trial. And you also have the right to go it alone, all by yourself. And so those are your 2 options. Which of those do you wish to take?
Well, I have some concerns about being represented by an attorney because attorneys in this state are licensed and franchised to make a living in the plaintiff's courtroom only at the pleasure of the plaintiff, right?
No.
Well,
I mean, you're under you have a lot of unfortunate and incorrect impressions. You really do. And that's really unfortunate. And I'm trying to, let you know. And again, you're just wrong about a lot of things. And I'm sorry about that.
Does the plaintiff have the power to disbar the attorney if the
No, absolutely not. I don't know why you would think that. That's completely not true.
Well, I personally know attorneys who have been blacklisted because the courts don't like the way they defend clients because they do it too effectively. For example, Lee Eckhart was not disbarred because he never did anything wrong, but he was blacklisted, which means any client he hired automatically lost. And he had to inform each client that wanted to hire him. He would lose.
I don't know anything about that individual. I don't know anything about that. You're asking me, I guess, in this court, whether or just generally, whether the plaintiff, in this case would be the prosecutor, has the right to disbar attorneys. And the answer to that is no, they don't.
The plaintiff is the state of Washington because Washington.
Well, in the city of Tumwater, in this case, remember we talked about that.
Yeah, but the city of Tumwater is a subdivision of the state of Washington.
But they could still bring case. So again, what do you want to do for your upcoming trial in terms of an attorney, or have one with you, or go it alone?
I'm not sure I need an attorney at this point because we'll have to see.
So again, that's a binary choice. So then from that, I can tell you you're choosing to go it alone. And have you ever done this before? Have you ever conducted a trial of any sort?
Just look at my record.
That's, again, I can see your record, but none of it tells me whether or not you've done a trial by yourself before. So, Mr. Blatt, have you ever conducted a trial before by yourself?
I didn't come here to answer questions. I'm sorry.
Okay. Okay. So then I'm going to talk, and then we're going to set a date, and then we'll conclude the hearing.
I need to bring something to your attention, if I may.
I'm sorry?
I need to bring something to your attention. The United States Constitution at Article 1, Section 1 states that when the state is a party, which is this case, excuse me. Let me get my glasses. When the state, it says in all cases in which a state shall be a party, the Supreme Court shall have original jurisdiction. This is in the United States Constitution. Now, the Washington State Constitution says that a frequent recurrence to fundamental principles is necessary. This is a fundamental principle. When the state is accusing a citizen of a crime against the state can't take the defendant to trial in its own court. That would be a conflict of interest. It has to take it to a neutral court, which is the United States Supreme Court. It says it clearly here at Article 1, Section 1 in the United States Constitution.
So, again, I'm going to speak for a few minutes, and then I'm going to turn it back to you, and we're going to set a date here. And again, I don't... First of all, this case is headed for trial. And again, it doesn't appear that you're interested in having an attorney appointed to represent you, so you'll be going it alone. When you have the constitutional right to do that, but you need to know that you're not an attorney. Apparently, you have very low opinion of attorneys generally, and a very low opinion of the system itself. Could you tell Mr.
I have no problem with the law.
Hang on, let me finish. I'm not done yet. The city of Tumwater is going to be represented, and I know you don't like that term either, by an attorney. That attorney is trained in the rules of evidence, trained in the rules of procedure, been through trial many times. And again, I don't know whether you have or not. And so they are experienced in the rules of evidence, which is important. You spoke disparagingly of the rules of evidence earlier. And they have training in that, which again is important. And I'm going to assume you don't. And many of the things that you've talked about, you're incorrect on. It's unfortunately, you're just incorrect about some things. And so you're going to be at a big disadvantage when you go to trial without an attorney going it alone. Do you understand this?
Isn't it the prosecutor's job to decide whether I'm wrong on issues? You're supposed to be neutral. The prosecutor hasn't even argued against me, and you're already saying that I'm wrong.
No, I'm trying to, believe it or not, and you probably won't. I'm actually trying to help you, let you know that this is just the way things are going. This is the way that this will happen. I'm not siding with the prosecutor. I'm just saying that this is what, and it's not the prosecutor's job really to decide what the prosecutor and defense, they disagree all the time on what the law is or what should be. And then I'm the one who gets to decide one way or the other. But some of the things that you're saying are so outside the norm that I don't need to hear from them. And I'm trying to let you know that what you think is going to happen and what you think the way things work is simply just not correct. And, I'll go back to that fundamental, I can't speak to the way juries were back in the 19th century. I just know how they are now. And I know that the jury's job in the cases of this sort is to find facts. That's what it is. And the judge is going to instruct them on the law. That's how it is. And the judge is going to determine what's going to be admissible or what's not. And that's just the way the trial's going to go. And I'm trying to let you know that is just to give you advance warning. So when you're in the middle of a trial saying, hey, what's going on here? You just at least have an idea of what's coming. That's all I'm trying to do. And I want to make sure that if you go to trial alone, you're going in with open eyes, understanding that you're at a fairly huge disadvantage. And so, but knowing all that, that's still the avenue you want to take.
You said the jury's job is to decide the facts, but there's no facts to decide because I'm acknowledging all the facts. I'm acknowledging all the facts. I'm not going to challenge them. I'm not going to fight with the prosecutor about what the prosecutor wants to fight about. My issue is the law. And I'm not saying the law is wrong. It's a question of whether the law, this particular law that I'm charged under, applies to me, whether I'm a person within the meaning of the statute. Now, the jurors are taxed to pay legislators to make up laws for their benefit, yet they're not allowed to know what the laws are. Don't you think there's something wrong with that?
Well, I guess my response to that is, I think most people are aware that when you get behind the wheel of an automobile and conduct it in traffic, you need a license. And there are certain things that can happen that can get your license suspended. I think most people know that.
Well, my position is I never had a license, never applied for a license, and I was not engaged in traffic. I was engaged in travel. Traffic is going to be the issue at this trial. And
well, then it'll be up to the jury it'll be jury determined whether you were in traffic or traveling. That's
excellent.
And the issue that you said, well, I never had a license, so it couldn't be suspended. I've seen people try this before, and I've never seen it work. And so here's what we're going to have. Hang on just a second. Here's what we're going to do today. So right now, trial is set for October 29th and 30th. Jury confirmation is set for October 22nd. You said you had a motion you want to bring. You can, that'll be heard on, what do we do? Yeah. That'll be heard on October 20th. You need to have that filed in writing by October 6th. And the state will have their response filed by October 13th.
Your Honor, if we could please request the defendant's email address so that the response motion can be sent to him, as he's not per se.
Did you hear that, Mr. Blatt?
Not really.
They want it because so you're going to file something, and they're going to see it. They should have the opportunity to respond to it, and they want to get their response to you, and they want to do that through email.
That's fine.
So what is your email?
LeonSBlatt@yahoo.com. LEON, S as in Sam, BLATT.
Did you get that?
I did, thank you.
All right, Mr. Blatt, I think that's it for today. And then at that particular time, the judge, whether it's me, whether it's one of the other judges here, I don't know.
How many judges work in this court that could be on this case?
4.
4, okay. Can I have their names?
Sure. There's Kayla Wilcox, Brett Buckley. You already know my name. And then there's a commissioner named Paul Wolf. It's all on the district court website. You can just go look at it.
Okay. Thank you.
And my guess is that judge, whoever hears the motion, is probably going to have a conversation with you again, or at least try to, about the concept of representing yourself and the disadvantage. And again, I know you hate that word. I'm sorry if that offends you in some way, but or going to trial alone without the assistance of an attorney. That's just.
I never expressed hate for any statute or attorney or wording or the.
I don't say that. Again, I'm not suggesting you are. I think that, or if I did use that term, I apologize. I just think that, you know, I'm spending a lot of time with this because I just think you're under some misunderstandings of a lot of real basic points. And, you know, in terms of we're here in district court, the state of Washington, you want to talk a little constitutional law, state of Washington Constitution sets superior courts of records. It's also in the Constitution that they can set and create such inferior courts as, you know, by statute through the legislature. The legislature has done that. They have established this level of court through Chapter 3 in the Revised Code of Washington, if you want to look there. There's also a mechanism in place where district courts can contract with municipalities to provide court services. All this stuff has been litigated through the Court of Appeals and the Washington State Supreme Court. And again, it's just pretty standard stuff. And I've tried to spend some time explaining it to you. Unfortunately, I don't think I've been very successful. I'm sorry about that. I wish I was more successful, but you can research all that out. And I guess when you talk about one thing, I will go back to that I should have said earlier, when you say the jury, you want to argue the law to the jury and shouldn't they know the law and so forth. You know, a lot of that happens in the Court of Appeals and the Washington State Supreme Court. You know, again, I'll instruct the jury or whoever the judge is, whether it's me or one of my colleagues, will instruct the jury on the law. The jury will decide the facts and then apply the law as I instruct them to it. Now, if I'm wrong about the law and you turn out to be right, all that's handled at the appellate level. You would file an appeal if you're convicted, and then you would, the court at the first superior court would look at it and see if I made a mistake on the law, or you're right on the law, and then it keeps going up all the way to the Court of Appeals, and then eventually to the Washington State Supreme Court, although they may or may not choose to take it. And so that's where the issues of law are decided.
Everything you just said about the evolution of the law is true. However, the Washington State Constitution says that a frequent recurrence to fundamental principles is necessary for a free state. That's what it says. So that means we eventually get so convoluted to oppress citizens of the state that we have to go back to fundamental principles.
Right. And again, I do want to address your last thing, you know, in terms of oppression. Again, let's remember what we're talking about here. And that is your license was suspended and you were alleged to have been driving. I know you have to say, well, you were traveling or whatever. And that's just, again, the only issue is, were you conducting an automobile and was your license suspended? And that's it. That's what this case is all about.
An automobile is different from a motor vehicle, and I believe the statute refers to motor vehicles. Motor vehicles encompass a lot of things. A motor vehicle can be a motorcycle, it can be an automobile, it can be so. And I think that that's generally pretty accepted that an automobile is a motor vehicle. No,
I believe that it is.
A motor vehicle,
unless it runs by. Unless it's the Flintstones where they just run on the ground, then that's not a motor vehicle. But I'm joking. Perhaps I shouldn't be.
A motor vehicle is a specific legal term in commerce. It's a business machine, like a truck, a taxi, or a bus that makes its business on the publicly funded roadways, which it does not have a right to do. A person
again, in Washington, and again, a motor vehicle includes a car. It does. And again, where do you get your driver's license? You go to the Department of Motor Vehicles, the DMV. That's where you get a driver's license for cars. And so it makes sense that, and again, I don't want to, we're going down a rabbit hole that was really not productive for either one of us, frankly. But, and again, I will just tell you that a motor vehicle includes automobiles within the terms of this statute in this state. It just does. And you can argue
I'll address this in my
otherwise, but you're not going to be successful.
I'll address this in my briefs and my motions, but of course the prosecutor and you will just pretend like you haven't even read it, like it. I've been through this many times.
I'm going to stop you again. I won't speak for the prosecutor, but if it's me, I'll read it. I'll read all of it.
But my experience has been, I'm sorry to say, to accuse you, but my experience has been that judges will just pretend that they haven't read it. They'll say, I read it and I found it's not correct. But they never talk about the issues.
Again, I don't want to talk about things that haven't even happened yet. So maybe it'll be me, and then we'll see what happens. But do you know when you need to get your brief due?
By October 6th. October 6th, and the response by October 13th.
And we'll all reconvene on October 20th and hash it all out. Whether it's me or one of my colleagues, I don't know.
Okay.
That'll conclude the hearing for today.
Thank you.
You're welcome. So Mr. Lease was on. You're free to go. Mr.
All right, I'm going.
He left. He might have been called by his attorney.
Next case I have is Vincent Haynes. Mr. Hayes, can you unmute, please? Mr. Haynes, can you unmute, please? I can see, there you go.
Okay, sorry
Okay.
about that.
That's all right. All right, so Mr. Haynes, you have two cases set. We have expired registration and failure to maintain financial responsibility. And you have indicated that you wish to plead not guilty. And are you requesting a jury trial, sir?
I grant the court use of my name for future return on my equity. I say again, I grant the court use of my name for future return on my equity. Your Honor, I have to object because I never made a plea. You made that plea for me. I did not make a plea. If I make a plea, it is a plea for release. I need to make a plea for release.
Okay, so Mr. Haynes, that's not a plea that applies in this court. You're using civil law terms like this were a civil court, and it's not. This is a state-created criminal court. And as I went over with everyone here, you have three options to plead. You can plead guilty, you can plead no contest or not guilty. And by law, if you do not enter a plea in this court, then by law, I have to enter a plea of not guilty for you. I do appreciate you reminding me of that you indicated that it was, you're correct. I did enter that plea for you because you did not enter one of your three plea options. You are set tonight for a pretrial hearing. We sent you an order of pretrial hearing and the complaints back on August 12th. And I do not see that you filed any requested motions or requested jury charges or anything. I do see that you posted a cash bond for these charges on August 6th. Did you send in any motions or requests pursuant to the pretrial order that I issued back in August, sir?
I did not. I did not see that email. I was looking for those instructions, but I did not. I would like to make a motion to dismiss, and for lack of jurisdiction and lack of venue. I'm a natural born person, and I have a right to face my accuser. And you're telling me that there's a crime that's been committed. And I know that there's no crime against me traveling. Ma'am, I was traveling, and my right to travel should not be infringed upon.
So, Mr. Haynes, you filed a motion to dismiss that was heard in court on August 6th, and the state responded, and and that was the court ruled that was denied. Therefore, the court does find that we do have jurisdiction for this charge, and so your criminal charges, which are Class C criminal offenses, are pending here at this time. So, other than that motion to dismiss, I do not see any other motions filed. Mr. Bishop, is there anything from the state? Any motions filed from the state? You're muted, sir. I'm sorry.
No motions from the state, Your Honor.
Okay. So, Mr. Haynes, a plea of not guilty was entered on your behalf by the court because you did not enter a plea at that time. Are you wishing to change that plea to either guilty or no contest? I need you to say yes or no out loud. I'm sorry, sir.
Ma'am, I mean, I asked, for, even in the last time we had this hearing, I asked for your jurisdiction, and you're just telling me that it's a state jurisdiction matter. And I mean, I didn't understand how, I have to understand that, and I don't understand that.
Well, sir, you are charged with fair to maintain financial responsibility and displaying an expired registration. And Texas law requires that people who operate a motor vehicle in the state of Texas obtain and maintain a certain amount of financial responsibility. Oftentimes it is insurance, but there are other ways to provide it. And that they register their vehicle every year with the state. And so you are charged with violating those charges, which are Class C charges, and you received that notice in the citation.
I signed that ticket.
Sorry, I'm not done, which was issued to you, and
Okay.
you also received notice in the complaint that was sent to you in August, on August 12th, and we can send the complaint to you again, but those are the charges, and you have received notice of that.
Okay, I'll send those charges again, but if you look at my ticket, Your Honor, I do not contract with the state. I rescind the contract pursuant to US 15.
Sir, this is not a contract, and the US code in regards to contracts does not apply to Class C misdemeanor offenses in the state of Texas. So that does not apply here.
You're conducting matters for money, and you're saying that there's a crime committed, and I just don't understand. So there are several things that I really object to.
Okay,
And like
well,
you
sir,
said,
listen, as you've heard me, because this is your second time to appear in court, you absolutely have the right to go and consult an attorney. And you may seek that attorney's advice, and you may hire someone if you wish to do so. All right, sir. But this is a Class C. These are two Class C charges. And the information in regards to that, the citation and the charges are listed on the citation that you were given a copy of, and they are listed in the complaint, and we will gladly send you another charge to that complaint, another copy of the complaint, excuse me, sir. So if we have no other pretrial motions at this time, if you do not wish to waive your right to a jury trial to have me hear your case, we need to go ahead and schedule this for a jury trial.
jury trial.
All right. So give me just a minute to look at the court's calendar. All right, Mr. Haynes and Mr. Bishop, the next available dates for jury trials would be either November 12th or November 13th. Do either of you have a known conflict to those dates at this time?
I do not.
Okay.
Your Honor, I do not. Either the 12th or the 13th of November, no.
All right, so we're going to set these for jury trial on November 13th. That's a Wednesday. I do believe that Monday is a holiday, so that will give us one additional business day beforehand. And so, Mr. Haynes, we do have our jury trials in person, so you will need to come to the court. I'm going to schedule both of you, the parties, to be here at 8:30. You will receive juror information. You will be able to conduct voir dire, which is questioning of the jury. The jury will be selected. Have any witnesses and documentation ready, because you'll have your trial that day. All witnesses and all documents, all evidence will need to be ready at that time. So let me make a notation here. So jury trial, November 13th. Parties here at 8:30 a.m. The veneer panel will be here at 9, and we'll begin the jury selection process very soon after 9 a.m. Any questions, Mr. Haynes?
Nope.
Okay, thank you very much. Watch your email. Do check your spam folder, because there will
I'll
be
have to check my
attachments.
spam. Yes, ma'am. That's
Okay.
what I have to do. I have
Okay.
to check my spam.
Okay,
That's correct.
so we will send you a reset notice for that setting. We'll make sure to resend the complaints. All right. If you have not received them by Monday, please call my court staff. They will resend it while they're on the phone with you to make sure you've gotten them. All right.
Yes.
Okay. All right. You're released at this time. We'll see you back here November 13th at 8:30 in the morning. Thank you.
The record. record, please.
Morning, Your Honor. Attorney Benjamin Stolper, appearing on behalf of the city of Burton.
Thank you. Mr. Renfro, if you would state your name.
Christopher Allen, House of Renfro.
Thank you. Today is the date and time set for a jury trial in the misdemeanor matter in this case, and then we also have the 2 civil infractions that I plan to handle after we finish with the jury trial. I just wanted to have a short pre-trial to ensure that we are ready to proceed on that jury trial. And so, Attorney Stolman, are you ready to proceed today with the jury trial?
Yes, Your Honor.
Okay. And Mr. Renfro, are you ready to proceed today on the jury trial?
I'm always ready to defend myself, but I still do not
Can you stand up,
consent.
please?
I still do not consent to these trials. These are done on fraud for the tickets were what initiated the stop. And now you're trying to get me on a crime that hasn't even been, we haven't dealt with the initial problem here. So until that's dealt with, how do we know if I committed a crime?
All right, well, one, I'm not trying to get you on
And what
anything that's not,
jurisdiction
stop,
is it?
I'm not
I'm
finished.
speaking.
Mr. Renfro, you stopped speaking and then I started speaking, and to be honest with you, it doesn't really matter. When I start speaking, everybody else stops. That's how court works. I've already warned you of that multiple times, so don't test me today, because we're gonna be in front of a jury, and if we start doing it in front of a jury, like I've also told you before, it's not going to happen. I will excuse them, we will have a conversation, and I will hold you in contempt, okay? As I was saying, I'm not trying to get you on anything. I'm the court, prosecutor's office files charges. There's 1 misdemeanor charge, there are 2 civil infractions. You will have the opportunity in your trial to question the officers and to have those questions answered that you have about why you were stopped and et cetera, et cetera. That's why we have the trial, and that's why we're having the trial. I am well aware that you do not consent to these proceedings. I am well aware that you don't think the legal process in and of itself is legitimate, but the simple fact is that it is, and you are supposed to be here, and we are moving forward with this case today. So what we will do is this. Now that we've established that everybody is ready to go on the jury trial, I will let the jury board know that we are ready and that we are proceeding today. So anyone who has witnesses that need to be here, make sure that they are here. Make sure you have all your documentation in order. If there are any exhibits that the parties wish to present, I would appreciate if you at least try to exchange those exhibits in advance. I know it's a little bit more difficult case than some others, but at least try to do that. And let the other person know, maybe there could be a stipulation or not, that's okay. And then the last thing before we take a break, which is what we're gonna do, we're gonna take a break so that we can handle the rest of the cases that are here, and then we'll start the jury trial. The issues of jurisdiction, I've already ruled that this court has jurisdiction. That's not an issue that gets brought up in front of the jury.
I
I
have a right to.
don't. You can object to evidentiary hearings or evidentiary hearing issues. You cannot object to jurisdiction in front of a jury. If you do it, I'm going to excuse the jury, and I'm going to hold you in contempt for not following the rules of court. These are not my rules. They are the rules of the courts of Michigan. In this big book here that I hope you've read, because you're getting ready to start a jury trial, and I really hope you've read these because it's the court rules and the rules of evidence, and you need to know these things. Because if you don't do it right, I'm not gonna give you any leeway on that. We've already talked about this. One more time, Mr. Renfro, are you sure that you do not want to speak to an attorney about this matter before you move forward?
I'm sure. Actually, I do not have my discovery for the case. I haven't been able to go over the evidence. It has not been served to me. I do not have the police body cams that I've requested a long time ago. I paid for half of them. I've not received them. I've not been able to go through any evidence. We're trying to get me on crimes before the initial stop was a civil infraction and somehow read a crime out of that. It's an unarrestable offense, the civil infraction. You cannot, that's fruit of the poisonous tree. So now we're here on crimes, taking care of the initial problem. So the tickets have to be first, and we're not moving anywhere until we get that clear. And you're in improper jurisdiction, subject matter jurisdiction, and personal jurisdiction. And we're not gonna move nowhere until we get this taken care of. I demand this court to vacate these matters. I say vacate, you say dismiss. Vacate these matters immediately.
Yeah. One, I've already said that I'm not going to vacate, and dismiss is the right word. I already said that. Two, I've already said that jurisdiction is appropriate. We have subject matter jurisdiction in this matter. We also have personal jurisdiction. Subject matter jurisdiction is because you're in a criminal court in the state of Michigan. And that is what we are dealing with. In fact, it's a misdemeanor, so you're in the right criminal court being district court. So we have just subject matter jurisdiction. We have personal jurisdiction over you because it alleges that this matter happened in Burton, and Burton is in the jurisdiction of the 67th District Court. So we have both personal and subject matter jurisdiction. Those issues are laid to rest. If you want to bring them up again, you can bring them up on appeal. You will not bring them up again in this hearing because we are getting ready to start a jury trial, and those are issues that are not appropriate to bring up in front of the jury. And as far as your issues of civil infractions leading to misdemeanors, happens all the time. All the time. And it is legitimate as established by our Supreme Court. So you can say that if you want to, but your argument is inaccurate. Once again, Mr. Renfro, your argument is inaccurate. You didn't answer my question. My question was, do you want to speak to an attorney before you move forward?
I'm a competent man.
Is it yes or no?
Lawfully competent man, no.
No. The answer is no. All right, I've asked you that question many a times now. I don't feel like I need to ask it to you anymore. You've established very clearly that you're going to represent yourself in this matter, for better or worse. Attorney Stolman, do you have anything that you would like to say in regards to any of the issues that Mr. Renfro has brought up?
Judge, I know he has not made a demand for discovery or request for discovery. I'll give him another copy of the police report. It's the only thing he's asked my office for, another copy. I believe he has made a FOIA request to the city regarding documents. I don't know whether or not that request has been granted, but I don't believe the FOIA request was all relevant to this case. I believe it was for more documents.
And I believe, Mr. Renfro, you've stated that on the record previously, that the body cams or whatever those were, that you FOIA'd them. The prosecutor's office is required to turn over to you all of the evidence that they have and all the evidence that they plan to use, and they have done that. We've had discussions about discovery numerous times. We're not going to delay the trial any longer. So we're going to have this trial today. Okay.
We have no exhibits that we're planning to introduce. We're just going to have the testimony of the officer. This is Mr. Renfro if he chooses.
Okay. Are you trying to say something?
Is the warrant in here? I don't see the warrant. Or the,
This is the second time you've been given those documents. Do you have the warrant from last time? Or the other time
I've
that
asked
someone
this
gave you that?
court numerous of times for the discovery. I have to have it to fight in the trial. I have to have the exhibits to be able to see what's going on or the moves that were made to get me in this position. So that
Answer the
warrant,
question, Mr. Renfro. The question was last time when they delivered to you the discovery after you refused it. Because you actually said you didn't want it because you were confused about how the court rules work. You got the discovery. Did you get the warrant in that discovery? It's not necessary,
I didn't
just so
get
you
the
know, but I'm gonna
discovery.
make sure that you have it. Do you have it or not?
No.
Okay, the answer is no. So here's what I'm going to do, unless there's an objection. I am going to provide the statements for probable cause as well as warrant and complaint copy out of the file. So Mr. Renfro has that. He doesn't have any complaints about not having it. Mr. Attorney Stolman, do you have any objection to that?
No.
Okay, all right, so we'll make a copy of that, Mr. Renfro, and I, quite frankly, I'm pretty confident that this has already been given to you, but we'll make you another copy so that you have it right now. Make a copy of that. Okay, all right, we will pause on this matter and we will come back in not too long and we'll get started on that jury trial. Thank you, everybody.
Thank you.
And then Mr. Giorno,
Thank you. Yes.
come on up. You're here on a couple of things, no valid operator license, but with valid ID, and then a seatbelt ticket. So I guess we'll start with, those are two things. And again, a valid ID, that's the same, you're free to go if you wish.
Oh,
Yeah, you can go ahead and just go line up at the window. You can stay if you want to. No one ever does when I make that comment, make that offer, but.
Thank you.
Mr. Giorno, like, we get the license issue, that's a pretty cut and dried thing. You have a license now, it looks like you do. Looks like you got the license like 2 days later. And then, so how did you want to, so again, how did you want to proceed on the seatbelt ticket?
Well, I'd like to contest the hearing, Your Honor.
So you're contesting on this speeding ticket, but then mitigating on the valid
Seatbelt issue.
seatbelt ticket, I'm sorry, you're right. You're contesting the seatbelt ticket, but you're mitigating then the license issue?
I'm contesting it, Your Honor.
Okay, okay. Could you raise your right hand, please?
Yes,
You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Seatbelt ticket first. What, did you get a chance to review your police report?
I did.
Okay. Go ahead.
And I set forth a motion for discovery. And I had a couple of questions and.
And you submitted, give me just a moment. So you submitted a discovery request?
I did.
You did?
Yes.
Did you ever get anything?
I did. All I got was a printed tick the box return. I had two questions that weren't answered.
Okay, so what, give me just a minute.
Okay.
Okay, so the discovery, I hereby set forth a request for discovery concerning the above case.
Yes.
And then I also request any evidence that you're subject to the codes concerning this case. And you request any evidence that you're in any type of contract concerning this case.
Yes.
Okay, so the discovery typically is a police report, an affidavit or some sort that says what happened out there. Did you get that?
I got a tick the box.
Right, that's
print.
That's right. So that's the evidence there. And then on your the codes, it should say on your infraction where you were served with that. It has the right there. You go look right next to there. They'll have the codes there.
Your Honor, I was asking for some evidence that I subject to these codes. I got nothing from the prosecutor's office. I didn't get a reply to either.
Well, they don't have anything to that about that, first of all. And secondly, I request evidence that you're in any type of contract concerning this case.
Yes.
There isn't any.
Right.
So that doesn't have anything, whether you're in a contract or not. I don't know why people make this argument to me. I really don't.
Okay.
But there's rules of the road. You need to comply with them. There's, you go on the freeway, you see all the people on I-5. None of those people have contracts to drive on the highway, but they're required to follow the rules of the road, including have a license and don't drive under the influence of alcohol, maintain the speed limit and all that sort of stuff. There is no contract of any sort. That's just the rules you got to follow. And that's been litigated quite, for a long period of time. And the absence of any sort of written contract or oral contract with anybody, I will tell you that that's not a winning argument. It's just not.
Okay, but returning to being subject to the codes, there was also no response from the prosecutor's office as far as being subject to these codes.
Again, anybody who drives on the road are subject to the rules of the road. I mean, they just are. You don't have and again, taking that away from the traffic, you're not allowed to rob a bank either. You're not allowed to assault people, but there's no, you just live under those codes. You don't have, no one ever came to you and said, hey, you're subject to the code that says you can't assault people. The same is true with driving. you have to be licensed. In order to be licensed, you have to take a test. You have to both driving and written. And then that when you choose to get on the road, you're subject to those, you're just subject to all the laws in the state, whether or not it's traffic or not.
I understand but there is no injured third party. You abide by the rules, no one gets injured.
That's, and again, I've heard that too, and I have zero idea where that comes from, because that's just not true. I mean, like, for example, then people could drive drunk as long as they didn't hit anybody, they're fine. But that's certainly not the case.
Well, that would be,
that
would be reckless driving.
And you can commit crimes without hurting individuals. I mean, just because no one got hurt, no harm, no foul might work in the NBA, but that's not in terms of the rules of the road. You have to comply with them. So again, the issue, and again, I will tell you what the issue is. They're very narrow, right? What you're charged with is not having a license, but without identification, or not having license, but with identification. And so that's it. I just make a determination. The police officer said in his report, you didn't have a license with you. And then it looks to me like you got one shortly thereafter. And that's, did you have a license when you were driving or not? That's the only inquiry. The second inquiry is, were you wearing your seatbelt or not? That's all there is to it. And so that's what I'm asked to decide. So I can swear you in and I'll hear from you. And then following that, I'll read the report and then I'll make a determination on those two issues, whether A, you were wearing a seatbelt, and 2, you were operating while you didn't have, without a valid license at the time. That's it. And you could mitigate, you could admit that, and that the license ticket, that's an expensive ticket. And so again, if you want to think about what you want to do, I think Mr. McIntyre, I think, is probably taking a little bit more time than we thought. So I can take care of him if you want to think about what I'm saying. Maybe this is coming as news to you. I'll hear from Mr. McIntyre, and then I'll come back and hear from you. Mr. McIntyre, you can activate your microphone. How did you wish to proceed here today? You're muted. Okay.
Yes, sir. Yes, Your Honor. I would just like to get a deferral.
Okay.
I'm not disputing with the officer. I did not have my seatbelt on. I just would like to apply for a deferral because this will be my 3rd ticket and I'll lose my license and I won't be able to drive it. And I use a company vehicle to work.
You can have one. This will be deferred. You can get on the Thurston County District Court website. It's $150 and you need to pay that within 90 days. And then there's a procedure how to go pay that. And you can certainly do that.
I'll pay it this week. I just don't want to lose my license.
You're free to go.
Thank you. Thank you, Your Honor.
What letter end? We'll deal with it when we get back. So, Mr. Giorno, where are we at?
This is
I've got one last thing I want to say about the prosecutor's responsibilities. They're required to give you everything they have regarding this case. And this is all there is, just that police report and the citation. So there's no, this isn't a speeding ticket. There's no speed measuring device. There's no pictures or anything like that or video. It's just the officer's report saying that you didn't have your license and that you didn't have a seatbelt. So what do you want to do here today?
Well, I had a seatbelt on and I would like to.
So if you want to contest it, then I can't even remember now. Did I swear you in?
Yes, sir.
Okay. So talk to me about the seatbelt.
Well, the officer's report is fabricated hearsay. I say it's inadmissible hearsay, and I motion to strike because.
So hang on just a minute. Let me get the report up. How is it hearsay?
It says I admitted to it. I did not. Of course not. And I would like to see the video. I'd like to cross-examine.
There is no video.
Okay.
And if you want to, you need to make a request to have the officer present in order to do that. If you want it, and then in the absence of having the officer present, I can decide it from the court rules are clear on that. I can rely on the report. I want to send it over for a period of time to most people, ask for the officer to show up, hoping they won't, if you want my frank opinion. But if you want, I'll give you the benefit of setting this over to have so the trooper can appear if you wish to do that.
Well, I object to that, Your Honor, because I showed up today and
Right.
it seems you.
But you need to, again, this is another example of you need to follow the rules. In order to have the trip, you have to provide a request for that in advance of the hearing. We never got the request.
Your Honor, I understand that it's the burden of proof is on the plaintiff.
True.
So the officer's not here.
That's
There's
true.
a failure to appear. So I can't cross-examine the
Yeah.
officer.
But I don't
he
think.
did say that it was videoed.
Well, they might not, they probably, again, on takes like this, we wouldn't have preserved that and sent it to the prosecutor's office. You didn't make the request to State Patrol to get that. You made a request to the prosecutor's office, what they had for the case.
Well, it's a little hard to discuss things with State Patrol.
What's that?
It's a little difficult to discuss issues with State Patrol when they are in a certain mode.
Okay, so what do you want to do here? Again, I'm still not too clear.
Well,
if you want to contest the seatbelt, we can do that. And then tell me what happened out there. Were you wearing your seatbelt? And if not, why not? And tell me what the misunderstanding with the officer is. Well, go ahead.
Well, the officer could not have seen what I was doing either way because he did a 180-degree wheel spin in the middle of Yelm Highway, where I've lived for 35 years, to pursue me. I, as far as I know, had a valid driver's license and have always had a valid driver's license. So I contest that I don't have any evidence from the prosecutor's office. I don't have any witness to cross-examine.
You do have evidence from the prosecutor's office. You have that report.
This is a print, Your Honor.
I know what it is. I'm looking at the same thing.
I have one, the original.
At the bottom of it, you can say it was certified under penalty of perjury. And then there's the officer's signature on there.
Well,
give me just a minute. Give me just a minute here.
Okay.
Yeah, the court rule says, with regard to the officer not being here, upon written demand of the defendant, at least 14 days before a contested hearing filed with the court and served in the office of the prosecuting attorney assigned to the court in which the infraction is filed, the prosecuting attorney shall at least 7 days before the court hearing provide you with a copy. That's not what I'm looking for. In a minute. Oh, yeah. On earlier in that same rule, a request that an officer appear at a contested hearing pursuant to this rule shall be filed in a separate pleading, and it may be directed. And then someplace else in this rule, it says, in the absence of that request, the judge, me, can rely on the police reports. And that is a police report. Yes, it's short, but that's what we have. And again, that's so. Do you have anything else? Because I'm ready to rule on these cases. Unless you, and again, I'll give you the opportunity to set this over and have the trooper present if you wish. You're here now. I don't have to, but I will give you that accommodation if you wish to take advantage of it.
So there's no prosecutor present, there's no witness present. I'm not having, doesn't seem I'm allowed to have a fair trial. I believe, if I'm not mistaken, it's an adversarial court system.
Right.
We have two parties. There is no injured third party. I still don't get an opportunity to cross-examine, and they have failed by default to appear. So I don't see why this should continue on.
So they don't, the prosecutor doesn't need to. They're not required to. And the fact that they don't on these infractions, again, they rely on the report. And so, and that's just what they do. And sometimes they do that to their peril. You don't know how I'm gonna rule on these cases. And sometimes these reports are incomplete, or I don't know, you were here at 1:30, they didn't even file one. So the case was dismissed and the woman who was there just left. And that happens sometimes too. And so the rules allow for this sort of procedure. And like I say, I'm giving you the opportunity to have that trooper present if you want to take it. And so you've complained about, he's not here. And I've tried to explain to you that it's not, there's certain things you have to do to get him or her here. And you didn't do them, but I'm giving you the opportunity to set this over so you can speak with them if you wish. And it's entirely up to you.
Well, I'm here for the hearing. I mean, it's going to be a fair trial. I mean, you seem to be, arguing for the plaintiff, whereas
I'm not. I don't mean to be doing that. I'm just trying to explain to you what the rules are, and in certain instances like these, they don't have to do things. And so I'm not saying about the sufficiency of the evidence. I'm not saying, well, you should be convicted for or be found committed for this reason or for that reason. I'm not saying any of that. I'm just saying these are the rules for this sorts of procedure. And if you perceive that as me being on the side of big arguing against you, I'm sorry about that, but that's not what I'm trying to do.
Well, this print that the officer gave me, I did not and was not able to see who was in his vehicle. So I have no idea who printed that up. I have no idea. There is no personal signature on anything. And yet again, I'm here and showed up and they don't have a case. They're not here.
Well,
I'm a little bit perplexed by that.
So here's what I'm prepared to do here today. With regard, you have two infractions here, and with regard to you're correct. You've shown up. I've sworn you in. I've listened to you testify. With regard to the seatbelt ticket, I'll give you the benefit of the doubt. It will be a finding of not committed on the seatbelt ticket. However, with regard to the license, based on the report of the police report, combined with the fact that on your ADR, which I'm allowed to look at, it looks like you were issued a license 2 days after this. It will be a finding of committed with driving without the license.
Your Honor, I forgot to bring my old license in. You can't read the date on it. I mean, it's just,
okay. So again,
it sounds like an entrapment. It's not like the Department of Licensing sends you a notice because license went in the laundry or whatever, you can't read it. And suddenly I'm just driving like normal, and it's like, oh, that's crazy. I couldn't even read it.
I'm going to go back to, and I'm going to say this one last thing, and then I told you how I'm going to rule on these infractions, but I will respond to that in this manner. And that is, it's, again, when you get on the road, it's your responsibility to comply with the rules of the road. It just is. And part of that is it's your responsibility to make sure you're appropriately licensed. And I'm not seeing it. You're right. You didn't see that. I don't know what it looked like when it came out of the laundry, but that's going to be my ruling on this case. And so they'll be not committed on the seatbelt, and that'll be dismissed. It will be committed on the no valid operator license, and the fine is since you got a license shortly thereafter, I will reduce the fine. I'll chop the fine in half.
But I got a discovery.
The fine will be, and again, hang on just a second. fine will be $280.
Well,
And again, I
okay.
tried to explain to you, that is the discovery, that police report, that's what it is.
But discovery did not say that I am subject to these codes.
Well, when you, again, I tried to explain that to you too. When you choose to get on the road, you know, you're subject to the rules of the road. You need to
Well,
follow
I
them.
object. This is
Okay.
not fair.
You can object and you can
I
appeal
will
if you
take
wish.
also. I will.
Okay.
I will. This is not fair.
You can go, you can give him a piece of paper. You can come up this and you can take this to the window and you can set up payment arrangements, file your appeal or whatever you wish to do. That's fine. You're certainly free to do that.
You're acting as a prosecutor, giving me a bill. I disagree. This is not fair. This is not a fair trial. They didn't show up. So the onus and burden of proof is not on me. I'm not subject to these codes according to the prosecutor's office. So I'm not subject to a fine until we have a fair trial.
Okay.
Fair and impartial.
Okay, I've told you what I've ruled. I've tried to explain to you the rules of infraction hearings. They don't necessarily need to. Sometimes they choose to, sometimes they don't. They don't have to. They filed the police report. I can rely on that. The court rules allow that. I know you disagree with that, and that's
the officer doesn't even have the decency to sign his own name.
And you can come and take this and you can take that to the window and set up payment arrangements. Or if you want to refuse to pay it, it'll be an unpaid infraction. And I'm telling you what I've done here today, and that's going to be the hearing will be concluded.
You didn't offer me another option that you stated at the opening of this hearing. You didn't offer me a deferral.
I did offer you a deferral. You told me you were wanted to contest it. I mean, I clearly offered you a deferral. I thought I said that at the beginning. I went through all three options. And
at the beginning when everyone was present.
Yeah. And I told everybody what their options are. And then when they come to the table, they tell me what they want to do.
Yes. Well, I was pursuing a line of contesting this.
Right. And that's what you did. And then I made my ruling. And I ruled against you, which is what happened here today. So you can come and get that or refuse to take it, whatever you wish to do, but this hearing will be concluded and that'll be it for this hearing. And so I'm going to take it, we're going to move to, I think everybody else on the Zoom call is at 2:30. There's someone on a phone number there who's ending in 55293. What's your name?
Well, kids, I just wanted to pause here for a second because that ends the whole block of sovereign citizen craziness that we had going on here. We've got a whole block of Judge Middleton coming up next, about an hour long. So if you need to, go ahead and grab some refreshments. Get yourself a drink or two. You're going to need some cookies. Blackboard is live. Ladies and gentlemen, it all starts right now. Thank you, NRH.
All right, as I indicated, we've got about 30 some cases today. We've also got a console, but this first matter is William Glenn Bontrager. That's you, sir?
Yes, Your Honor.
File number here is 251148. Got part of what I need, but not all of it. Let's see what we got here. Looks like you put everything in my queue, which is great. All right, well, let's talk about this. The file number here is 251148. It's alleged that on or about May 10th, you did carelessly, recklessly, or negligently allow a pistol in your control to be discharged. That's a misdemeanor, punishable by up to a year in jail and a fine of up to $500. This is with damage over $50. So they're going to amend it to reckless or careless discharge with damage under $50. Is that my understanding?
That's right, Your Honor. So the 90-day misdemeanor.
All right. Rebecca Lentz is the manager at Colonial Estates. Yes, I remember the arraignment on this. All right, Mr. Bontrager, the charge you're charged with is a misdemeanor punishable by up to a year in jail and a fine of up to $500. They've agreed to reduce it to under $50, which would be punishable by up to 90 days in jail and a fine of up to $100. It also requires a forfeiture of the gun, if I'm not mistaken. I think this had to do with you accidentally discharging a gun through one trailer and into the next one, is the way I recall from the arraignment. Are you going to plead to that lesser charge?
Yes, Your Honor.
Anybody threaten you to get you to do that?
No, Your Honor.
Or promise you anything?
No, Your Honor.
And you've assigned this advice of rights, acknowledging that you're giving up the rights that you'd have if you had a trial?
Yes, Your Honor.
Tell me what happened.
So earlier that day, I had picked up a new gun safe on Facebook Marketplace for $50. Later that evening, I got home, had dinner, put my kids to bed, and it was around anywhere from 10 o'clock to 12 o'clock. And I was putting everything away. And a couple weeks prior, I had gone to the range to safely and to the best of my ability practice with my firearms and get a good knowledge of them. And when I was moving stuff over into the new safe, I had realized that I had that I still had my revolver loaded. So when it was late at night and I didn't think anything of it. I pulled the hammer back and then I realized that it was loaded. So for a revolver, the hammer needs to be cocked down in order to release the barrel or the cylinder to empty it out. And so I was trying to do that. My thumb had slipped off the hammer before my finger got off the trigger, and hence the head went off.
All right. Well, to tell you the truth, I did this very thing when I was about 12. I pulled the hammer back on my dad's revolver. He was changing his clothes after going hunting, like this, and then I pulled the trigger and shot a hole in the floor. It scared the dog.
Absolutely.
My dad covered for me. My mom was in the bathtub, and he said, "Oops." But anyway, I'm lucky I didn't point it at the dog or something, but that is careless. But yeah, it went through your trailer and the one next door. All right, not exactly a bad intention offense, but it's a careless one. What do you do, Mr. Bontrager?
For work, you mean?
Yeah.
I set modular homes.
Who's your company?
Web Setup Incorporated.
somebody set a modular home up near where I live and they set it backwards.
Was it over here in Constantine?
No, it was a Fisher Lake.
Oh, I just did one over in Constantine.
This was a couple
not
of
a
days
week
ago. They had the front porch face backwards rather than toward the lake.
Oh, yeah.
So they had to come out and reset it. All right. Well, this carries a $75 fine, $75 crime victims' rights fee, and a $50 state minimum fee. Did you post a bond?
I did.
Let's see how much bond I have. I'm missing part of the file.
I had paid
You posted a
$300.
$300 bond.
Yes, Ron.
And we'll do a $100 restitution. So that comes out to $300. Posted $300 of bond. And I'm sorry, your 38 Taurus is going to be grounded up. Firearm is forfeited. All right. As I said, there are certain things under the law where carelessness becomes a criminal offense. Some of them has to do with automobiles and some of them have to do with guns and other things. But this is a careless act. I don't know how much the 2 small bullet holes were. I did not see a restitution request in here. So I'll just use that. Let me see if I can. By the nature of the plea, it was under $50. All right, sir. You're good to go. Mr. Westbrook, have you ever been down here before on a case?
No, Your Honor, first time.
I hope it wasn't a bad experience.
Not at all, very efficient. Thank you.
But you're welcome to come back. All right, you're good to go, sir. I've used your bond to pay your fine. And the gun will be forfeited, and I'm glad nothing worse than this happened.
Absolutely.
All right, thank you.
Thank you, Your Honor. In candor to the court, I do have an invoice from Colonial Estates. I don't know if that was a formal restitution
How much
request.
was that?
It was for $409. We are agreeing to pay restitution if that is a formal request. We can take care of that at some
All
point.
right, I'll have to do that. So 409, thank you. Appreciate that. So that's 609. Less $300 of bond leaves 309. You can pay it now, or do you need time to pay that?
Need time, please.
I'll give you till October. You can put on your credit card, October 5th.
Yes, sure. We can take care of that at the window, Your Honor, at that time.
Yeah, you can mail it in with a certified check or money order. Bring in green cash or pay online with your credit card.
Yes, sir.
Discharging a gun in a bedroom is pretty loud. All right, you're good to go. Thank you.
That was 309, Your Honor.
309.
Very good. Thank you.
Thank you, Your Honor.
Thank you.
Have a blessed day.
We're working on it. Miss Gibson, why don't you come up to the podium? I've got Pablo in the waiting room.
He has not appeared.
Oh, he hasn't? I thought he was here. Do you need him for anybody else?
No, I do not. And I have a staff member here that's able to assist as well.
Oh, yes. Let's see who you mentioned that to me. I don't know who else needs an interpreter. Giselle Gonzalez, I think she speaks English. Adon speaks English. Jesus Alcantar, I think we may need an interpreter for him. Let me take care of Miss Gibson, and then she was here and she left. She's still here.
I just have 2 quick final pre-trials.
All right.
I was going to scoot upstairs.
All right, well, let's do Mr. Nieves, and Good morning, sir. This is file 241818 SM, People versus Aden Nieves. Charge here is assault and battery, 2 counts. Here with Tim George, his attorney. It appears we're going to set this for a final pretrial.
That's correct, Your Honor.
Mr. Nieves, are you still on Virginia Street?
Yeah.
What are you doing now? Are you working someplace?
Right now I'm just working for my parents.
Well, you owe me $600 or $550 in that MD malicious destruction disorderly case from last year. When did you last make a payment on that?
Well, I just got out of prison July 16th, so I've been gone for a year.
I guess so. I don't even know what to say about that. I knew that you went to prison, and I'll just leave it alone. You're smarter than that. And at some point, I hope you finally get everything in order. At any rate, are you on probation now?
I'm on parole.
To who?
Jeb. Downstairs.
All right. Yeah, I'm sorry to even hear that. You and I spent a lot of time making some progress and then going backwards and making some progress and going backwards. At any rate, these 2 A and B cases precede your prison sentence. So these are not parole violations, are they?
They were the basis. Yeah, they were the basis for the parole violations in prison. So I just did a year for this.
All right. Well, we'll see what the prosecutor wants to do with it. But as far as this matter is concerned, you're free to go and about your business.
Thank you, Ronnie.
Thank you. And I would like you to start to pay on that.
Yeah, as soon as I can get a job and Jeb approves it.
Okay. All right. This is Ms. Balazet, Sonny Balazet, false report of a misdemeanor. We discussed this at the arraignment here with her lawyer, Mr. Tim George. Same thing, we're going to set a final pretrial conference in this matter.
Yes, Your Honor. And Ms. Musselman advising me that that's her last name now, Musselman. But we just need to get some more information.
You look like you're dressed for work. You had your keys in your hand. You want to get back to work?
Definitely.
All right. Stay in contact with your lawyer. I don't believe you owe me any money. Lots of people do today. But you're good to go. That will be on a Thursday at 2:00. I don't yet know the date. Are you still at the same address in White Pigeon?
Yes.
Murray Avenue?
Yes.
All right, you're good to go.
Thank you, Your Honor.
All right. Mr. Haley, why don't you come up and have a seat? All right, we're going to talk to Sean Haley. Good morning, Mr. Haley. Good morning. You're charged with domestic assault, and I didn't like it when I saw this come through, and you and I talked about it at the arraignment. Allegation is that you assaulted Tracy Warner. Her mom just died a little while ago.
Yes, she did.
She was a nice lady, knew her for a long time. Anyway, that's a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. Prosecutors agreed to reduce that to a charge of disturbing the peace. We just did one of those with the last guy that was here. You understand that that is a misdemeanor punishable by up to 90 days in jail and a fine of up to $100. You understand?
Yes.
All right, I don't have an advice of rights here, so I'm gonna take a minute and, oh, you got one?
I didn't have insight. No, I
All
didn't
right.
have extras. I'm
Well,
sorry.
I'll tell him and everybody else that's here, Mr. Gary, everybody, do you understand that if you plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury? There will not be a trial. Do you understand that?
Yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. Ms. Harden is here with you. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You'd have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. You understand?
Yes, sir.
All right. Were you and Ms. Warner in a dating relationship at that time? Michelle? I was gonna ask her to call the hall for me for somebody. Well, I'm looking for, Janie Gibson.
Janie Gibson, I'll yell in the hallway for you, sir.
All right. She's a good yeller. All right, so what happened on July 8th between you and Ms. Warner?
Well, Your Honor, I was working. I worked for the landlord and I was in the basement. And I'll put it like this. When,
Sir, Janie Gibson did not check in.
All right, thank you.
when you say no to not giving any money up, attitudes go flying everywhere. As I said, I was working, putting a hot water tank in, and she just kept babbling with me there and my boss there and everything. I'm in the basement.
Who's your landlord?
His name is Ron. Ron, I don't know his last name, but we've been together for maybe about nine years, and that's the landlord to her building. I work for him. So I'm there putting a tank in and she's babbling off. I think what she was trying to do is get me fired at the time so I can be, in the hole or something. So I didn't pay attention to her, try to just keep working. And all of a sudden you can hear things just boom, 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 boom. She was throwing my stuff out of the apartment onto the back porch. So when I came up the stairs and I seen it, my stuff just getting thrown, I pushed the door closed so she couldn't do any more. After that, I went back to work. I say maybe about 20, 30 minutes, police came. I'm at work.
Well, apparently something fell on her foot and injured her foot.
Probably all the stuff that she was throwing the mines out the door.
Pushed open the door and the chair fell on it when you pushed the door open.
Together, so.
Are you still together?
I haven't seen her since I've been out of jail because I was told not to go.
Did you go to Gay's funeral?
Oh, definitely. Yeah.
All right, but definitely. So you sat
it wasn't a funeral. She was cremated, and then they have a little family thing that they had. And,
all right.
It wasn't a funeral. But yes, I attended.
All right, I guess that's enough for disturbing the peace. Are you satisfied, Ms. Harden?
Yes, Your Honor, it was a
disturbance in a place open to the public, I think that satisfies.
Well, I'm about to lift the no contact provision. So you can have contact, but that's up to her. The problem is you don't have any money. You owe me money. I don't want to just give you another fine that you aren't going to pay. You owe $865 of fines, fishing without a license.
Oh, I was trying to figure out.
I'm not real worried about that. Allowing another to violate the motor vehicle code, I fined you $275. You paid none. In your drinking driving case last year, you were ordered to pay $340. You haven't paid any of that, so you haven't paid anything. How long were you in jail for this?
5 days.
I'll give you 5 days jail credit, 5 days. I'm gonna waive the fine. I'm even gonna waive the attorney fee, but you owe me $125. I want a payment plan on all files. Kind of payment plan where you actually make a payment.
Well, see, I can do it every first of the month. You know, pay something every first of the month because I'm on disability.
I'm aware of that. But you haven't paid anything on these. The OUIL was reduced to impaired. The driving suspended was reduced to a law and other, and then you just didn't pay them. But I don't really want to put you in jail for this.
Actually, I had not remembered any of those that I had to pay for, because if I did, I would have been saying something. Now that you brought it to my attention.
All right, I want you to go out to the counter and set up a payment plan on this and the others. I waived as much fines as I could because you did 5 days in jail.
Thank you.
But that one that has to be paid. All right, you can go with the court officer.
Thank you.
Thanks.
This is file number 251653. You're Monica Jean Roars,
Yes, sir.
and you also went by Monica Dean. Which do you prefer?
I prefer Dean because I'm not married anymore. So as soon as I go back, I'd rather go back to my maiden name.
But you haven't officially done that yet?
No, sir, I have not.
All right. Miss Roars or Miss Dean, you're charged with a strange case, arson. It's alleged that on or about August 15th, you burned some property that belonged to Clark Logic, some pallets. It's charged as over 200 or less than 1,000, which makes it punishable by up to a year in jail and a fine of up to $2,000. Prosecutor has agreed to reduce that to a charge of a plea to attempted arson. Over 200 to 1,000. That cuts it in half, makes it 6 months and or $1,000. Do you understand the charge?
I do, sir.
Anybody threaten you to get you to plead to this
No, sir.
or promise you anything?
No, sir.
Do you understand that if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury, and there will not be a trial? Do you understand that?
I do.
If you had a trial, you'd have the right to be represented by an attorney. Ms. Ives is here with you. You could also have an opportunity to hire an attorney of your own choice. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand yourself and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes, sir.
All right, were you down by the Clark Logic? They got a bunch of different facilities. This one was. They're just building a $15 million one in Kalamazoo. Down on 4th Street, cotton can plant. Did you attempt to set some,
I was walking the train tracks, but yeah, yep.
an attempt to set some pallets on fire?
I smoked a cigarette. I was like playing, you know what I'm saying? Like just burning them. I honestly didn't think it would take off. And I was actually sitting there crying about like just everything. I honestly didn't think it'd take off. And then when
But they caught fire?
yes.
All right. Well, you had that other case.
Right.
Where you set some stuff on fire.
I set the leaves on fire in front. Yeah, Kenny.
So I'm
Kenny Burt's
worried
house,
about
yeah.
whether there's a fire starter thing
No.
going on here.
No, that wasn't intent. This one was not intentional at all by any means.
Well, anyway, they caught fire and lucky it didn't burn the whole place down. There's all kinds of flammable stuff back there.
Well, I actually wasn't even by the building. It took place on the train tracks that they actually don't even use anymore.
Where were you just wandering?
I was just walking, figuring out where I was gonna stay for the night.
Have you got a place to stay now?
Yeah.
Where's that?
Well, I have two. I have my friend Scott's or I have my grandma's. I mean, it's just, I was actually sitting there mad at myself because of the decisions that I made and the position I'm in. Everything just kind of all hit me. Like my daughter's back living at my mom's, the one that was given up for adoption years ago that I've already lost years with. She's actually back in my life and living at my mom's now, but I can't go there because of another case. And so I was basically sitting there smoking a cigarette, debating on drinking. I chose not to drink because
Well, you had some watermelon liquor with you and a meth pipe, and you're just.
You're right, and I was just saying what to do. But when I didn't drink, and honestly, when he pulled up on me, I instantly handed him the pipe. He's like, "I don't want that." So that's all I have. And when he gave me a PBT, I blew all zeros. So I actually chose not to drink. I did have that, but in the predicament I'm in, like if I don't have something to go to, like all the houses that I legitimately had to go to at that time, they're all drug users. So if I really don't have anything to contribute to that house, like I mean, I can't have nowhere to stay. And that's exactly what I told him, and that's the truth.
I believe you. You burned a lot of bridges, no pun
Right.
intended. But
So
I'm worried about that earlier fire. I'm worried about this fire. With exactly what's going on with you. You owe $3,424 worth of unpaid fines and costs. A lot of them is just traffic,
Yeah.
but
I was working, I mean, honestly, I was working and it was hard working. I worked Dairy Queen. I've only worked granted, I only worked 2 days and I got thrown in here, but the simple fact is I was actually trying and it kind of sucks because who wants to go to work when, you know, you don't have a place to shower or you don't have this, you know what I'm saying? So I'm like, what? Like I was actually sitting down. I smoked like 3 cigarettes, like debating, like I was like, do I just wait for a train? You know what I'm saying? Or something like, I mean, literally like life had hit me right then and there. Like I didn't know what to do, but I honestly didn't, my intentions were not to burn anything. And I really didn't think that, I thought he was lying to me when he said, oh, you burned. No, I thought he was lying, but I guess not.
yeah, they caught fire.
Yeah, that wasn't my intention at all by any means.
Well, it's an attempt. So what happened? You threw a cigarette in there?
Yeah, I was just sitting there and like, cause they have wood pallets up by the building and they have a bunch of wood pallets by the train tracks that they don't use. And I was sitting at the train tracks where there's a 4th Street sign and the train, like there's a set of train tracks they don't use and they have all these pallets sitting up there. I was actually sitting on the pallets, just sitting there. It was about dusk and I was just like, what am I gonna do? Like I'm gonna have to work tomorrow. Like if I don't, you know what I'm saying, do certain, right. I didn't want to go to work. I hadn't showered in days. You know what I'm saying? It's just, my life is kind of, and I'm not mad at anybody but myself. So like, I don't know if you want to call it an epiphany or something, but like just like hit home. Like,
Well, I'd like to find a place for you to go. Because you just been on a downhill slide for several years. And there was another fire and there was this fire.
yeah, I do know Lauren at the gym or whatever. It is December or not December, it's September. So 9 months. Keystone is willing, they just said that they would take me back because it had been 9 months.
That's another place where you burned a bridge. You got kicked out of there.
Actually, I've redeemed my bridge there because I was just there over Christmas.
All right.
And they said, right, and it wasn't my fault, why, whatever, but they said I couldn't come back for 9 months. This time I didn't burn my bridge, like I redeemed myself. I was there over Christmas. I think it was the day after Christmas, right, the warming station shut down, so like Christy told me to come back in 9 months.
Judge Patterson is getting a pre-sentence investigation, I think is a real good idea.
Yeah, I have the paperwork right here. That's what I tried to show you earlier.
Says
Scheduled for the 12th.
9/12. So you're set for sentencing on 9/12?
No,
No.
October 12th, Your Honor.
October 9th.
Oh,
Says
October
here-
9th.
It says here 9/12.
That is my pre-sentence investigation
Oh,
phone call,
okay.
yeah.
I'd like to see it myself. October 12th is a Sunday. That can't be right.
It does say September 12th, 2025. Probation officer will call, but she's in the county jail. I'm sure Mr. Huff will look it up and realize where she is if the court wants to see this.
Yeah, it's not set for sentencing. It's set for an appointment at 9/12. And I can't tell from looking at it what the sentence is set for.
We have it on October 9th at 11 a.m. on my calendar, Your
All right,
Honor.
let's
My,
check
yeah, my
that out.
paperwork
All
too.
right, October 9th.
Because over here it says it. 10/9.
October 9th is a Thursday. At 11,
Yes, sir.
I set this for sentencing for October 9th. At 10:30. Review Judge Patterson's PSI. In fact, I'm just gonna make this part of the PSI in that case. It can get better. Started with 20 days of forced sobriety and no meth.
22, yeah. I have 92 days of no alcohol.
All right, well, I'm not so worried about the alcohol as much as about the meth. All right, I'm gonna set it for the same morning as Judge Patterson. And just a little earlier, October 9th at 10:30, so Rob, you don't have to make 2 trips. Monica, I'm not gonna amend your bond. You're a danger to yourself. I wanna find a place for you to go. If I let you out right now, you're just gonna be wandering around the streets again.
I would actually go to my grandma's, but
No, you won't. That's part of where the fire was. The
My
other
grandma's
fire.
is on
Yeah.
West Street.
Yeah, wasn't that where the other fire was?
No, the other fire was on, Kipker.
Oh, I thought it was on the curb at West Street.
No, sir.
All right, you can go with a court officer. Bond remains at 5,000 cash or surety.
I thought it was 250.
No, it's $5,000 cash or surety.
Which is,
And you owe thousands of dollars worth of unpaid tickets. Maybe I can wipe some of those out with this case. At any rate, I'll see you on October 9th. Michelle, who else do you have back there?
Long and Lori Allen. I have Miss Allen, I have Miss Long, I have several guys in the back.
All right, Lori Allen is also Luke's, and I have a stipulation to adjourn on her case. So she can go back. And I set Miss the other lady on there on short notice. Do we know what the deal is with Luke?
Yeah, he sent steps together for all of his cases.
All of his cases?
So we don't know where those are.
All right.
I talked to him.
They can, all the ladies can go back.
Long and Allen both
Yes.
go back to. Yes, sir.
Well, phooey. I didn't know any of that. And I looked at the calendar and he was on it. At the last minute, he adjourned all his cases. Two of who are in custody.
Your Honor, have a good morning.
I'm having a crappy morning, actually. Thank you. It's almost over.
Well, thank you for allowing me to do.
To contribute to my crappy morning. All right, now we've got Ms. Harden. Let's do, you got a lot of people in custody.
I have 3 in custody and then Ms. Nickerson did show up late today.
Yes, what does Ms. Nickerson want to do?
So the offer is to plead as charged to retail fraud third, and speaking with the prosecutor, they have agreed to a no contest plea due to lack of recollection.
All right, Ms. Nickerson, would you come forward, please? All right, this is file number 251037, Rebecca Lynn Nickerson. She got charged with retail fraud, alleged she was in the Walmart store on April 14th. I mentioned this to her at a zoning hearing and she didn't have much recollection of it there either. Ms. Nickerson, it's alleged that when you were in the store on that day, and you put some stuff under your cart. And they were watching you because they have previous incidents that they've been watching you. And the allegation is that you left the store with 8 items totaling $80.30. They didn't stop you then. They got a warrant, and that's probably why you don't remember this, because they didn't arrest you. See what the warrant issued. on May 15th, and then sometime after that, you got arrested. Retail fraud in the 3rd degree, or maybe I just arraigned you while you were here, I think. All right, retail fraud in the 3rd degree is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. It also could require restitution. By pleading no contest, you don't admit what happened, but you also don't deny what happened, and you would allow or accept that a conviction would enter. Do you understand? You have to speak your answer.
Oh, yes.
Is that what you wish to do here?
Yeah.
Your
Anybody
Honor.
threaten you to get you to do that?
Your Honor, just for the record, the report does indicate that they did have contact with her when she was leaving the store, but there was no arrest on site. So there was contact.
They saw me 3 times.
Oh, when she began to leave, they argued with him and left the store. Okay.
That was the 3rd person that went through my cart, yeah. The first 2 didn't find anything, that's why I was like.
All right.
I was,
Did you want me to watch the video of this?
no, I didn't understand because like the first person was the lady at the checkout. And then the guy that like the greeter. And then the 3rd gentleman, and it just seemed like excessive. And if they didn't find anything the first 2 times, I just, so maybe I.
Well, you're obviously quite repentant about this. They alleged that on previous occasions, they'd seen you doing this, so they were watching you the day you came into the store. So they alleged that you put some items in your cart, paid for the items in your cart, but did not pay for the items that were underneath the cart in the lower part of it. And there were apparently 8 items. Ms. Camfield, can you tell what those 8 items were?
Let me see.
Then you argue with them and left. And then they got your license plate, and that's how it came back. So by pleading no contest, you don't admit what happened, but you don't deny what happened. Are you willing to do that, or you want to have a trial on this?
No, I just want it done. What did you say, oil and nail polish and.
Yep, there were some figurines, some lawn bags, so.
And a lawn bag. And
There's a variety of things.
I can confirm that, Your Honor. I have the report.
And those property was not recovered?
Correct. And I was in my mom's car, so I don't know how that would come back to me.
The license plate came back to Rebecca Lynn Nickerson as the registered owner.
Okay. I don't. Oh, I don't remember. Oh, yeah.
Yeah, you were here, I think maybe on your zoning case, and I did the arraignment, so you didn't get arrested.
Right, it was, yeah, and yeah, that whole thing was just.
You don't have any money. You have a bunch of repairs you're trying to do at your house. You're still grieving. You're not the least bit repentant about this, which makes me want to put you in jail.
I mean, I am.
But no, you're not.
Yes.
You walked out of this stuff, you bitched the people out, left.
That was the 3rd person that stopped
All right,
me.
but that's because you
And
had
that was-
stolen stuff in your cart.
But if the
Stop,
first
stop. I'm trying not to put you in jail. Don't talk yourself into it by being recalcitrant. They knew you in there as someone that came in and steals stuff. So you can't go into Walmart anymore. You're barred from Walmart for 1 year. That's all of them. I'm not gonna put you in jail. There's a presumption of no jail, but I'm not even gonna give you a fine. $75 crime victims' rights fee, $50 state minimum fee, $150 attorney fee, and $81 restitution to Walmart. I don't really like being Walmart's collection agency, but that's what I do.
Do you have a payment plan, Your Honor?
Yes.
Thank you.
$356. We'll put you on a payment plan. I know you're trying to use your money to get your house in order. You didn't really need this distraction. All right, you go with court officer. And, then we'll start to get our people out of in custody. All right, good luck. These first Friday of the months have become very dense. This is only our 15th plea. The other day we took 23 and we didn't have much dead time. We've been really glued to the bench. Maybe I just don't move fast enough, but it takes a while to process each case. I took about a 3-minute break and they are missing lunch. The prime rib, they'll have to hold it for them. And the lobster will be gone by the time they get back. Good morning, sir.
Good morning, Your Honor.
You're Joseph Patrick Christ?
Yes, sir.
We've met,
Yes,
but I need to identify you, the record. You're here with your lawyer, Ms. Jordan Harden. The charge alleges that on or about August 16th, that you made an assault upon Shane Christ, a former resident of your household. Prosecutors, they ended up, this doesn't look right. It's charges a DV second. Let's see if there was an amended complaint charging.
They charged me with assault and battery as far as I know. That's what I was rearranged on assault and battery.
Yeah, then they charge it as assault and battery. Shane Howard Clark. You've been in custody now.
I believe 20 days, Your Honor. 20 or 21 today.
All right. The recommendation is you're going to plead to assault and battery, no domestic violence charges, and the prosecutor's recommending time served, which will be 20 days. Other than that, did anyone promise you anything to get you to plead to this?
No, Your Honor.
Or threaten you?
No, sir. I just asked that you please go with the recommendation.
All right. And do you understand if you plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury?
Yes, Your Honor.
If you had a trial, you'd have a right to have an attorney with you. And you'd have a right to hire one or have one appointed, and we've appointed one.
I understand.
If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court, so they could be questioned under oath. And you would have the right to take the witness stand and testify on your own behalf, but you don't have to. And if you did not wish to testify, the judge or jury cannot hold your silence against you. And you have the right to be presumed innocent, unless the state was able to prove your guilt beyond a reasonable doubt. Understand?
Yes, sir.
All right. Who is Shane Chris to you?
My brother.
What were you guys fighting about?
Just we don't really get along, and I'm under, from my knowledge, I mean, I woke up to him spitting at me and my eye was swollen. I mean, they said they couldn't see it, but I was so worked up when they got there that with the redness in my face from my blood pressure, I'm sure they couldn't see any redness, but he punched me in the face and my mom got in the middle of it.
So did you punch him?
When he pushed me, yeah, he pushed my mother out of the way, then he pushed me, so I did it self-defense. When he pushed me, I did give him a little gab, yes.
All right.
He had done that, and then he slammed the window. I went outside. I tried to come back in to get a portable charger station to charge my vape, my e-cigarette. And I opened the window, opened the blinds. He slammed the window down on my arm, told me, "You ain't coming back in here." He said, "I finally got you. You're going." He said, "You're going. I got you." And he had her call the cops.
All right. Had you been drinking?
I had not. I woke up. I woke up to the situation, and I don't drink, Your Honor. I don't drink ever. I just don't enjoy it.
Save yourself a lot of grief.
Yes, absolutely.
So are you gonna go back to this house?
I will go there, but as far as I'm concerned, it'll be just to get my belongings with I won't have to have a cop go there. I can go there. He'll go to work at 2:00 around there, and I will go. I'm gonna go there. I'm gonna get my property, make sure my car's all right, because it's disabled at the moment. Get my property, and I have places I can go, and I just gotta get out of this situation because it's toxic for everybody involved.
Yes, for your mom's had to deal with this before.
Yes, and she does not need to deal with it. I don't need to deal with it. He doesn't. None of us need this stress. I'm the problem for whatever reason it is. So I'm just gonna extract myself from the situation, sir. As long as you let me go today, even if you don't let me go today, I mean, I will extract myself no matter what. But I just ask you, please go with the recommendation, Your Honor.
All right. You got $1,715 worth of unpaid fines and costs, including some other stuff. So I'm gonna give you 20 days credit, 20 days, $125 fine, or 2 additional days. I'm not gonna chase you around for it.
I understand.
So if you pay $125, you get out today, otherwise you gotta wait 2 more days.
Oh, I have to wait 2 more days?
If you pay, you can get out today if somebody put up $125.
I understand.
But I'm not gonna give you another fine that you just don't pay.
I understand that.
All right, so you can go with the officer, hopefully maybe somebody bring you $125, otherwise you'll get out on Sunday.
Okay.
All right, thank you, sir.
Not a problem.
Thank
You're
you.
welcome. Thank you. Thank you. Have a good day.
Mr. Yes, Mr. White.
Did Luke write on the forms which files he's pleading to, since he has 4? I can tell you.
I think he did. That guy still looks like Shaggy. They've had that turmoil at this household before, but he hasn't paid his last A&Bs. All right, Mr. White, we're dismissing
109 and 492.
Good morning, sir. I'm sorry it took me so long, but I've been moving as fast as I can. You're Gregory Anthony White?
Yes, sir.
We've met before. I'm Judge Middleton. You have multiple counts of trespass under the City of Sturgis ordinance. File, this is disorderly person, 25492. from March is being dismissed, disorderly person. 25109 OM trespass is being dismissed. That's from January. You've been in jail for 19 days. What's left is a trespass from the city of Sturgis in file 25522 OM. That allegedly occurred on March 19th. And 25541, that occurred on April 9th. So they keep charging you with trespass, you keep not showing up, then a bench warrant issues and you got picked up, and now you've been in jail for about 19 days. Are you gonna enter a plea to 2 counts of trespass? Sturgis thinks that they can solve the homeless problem by continuing citing people with trespass, but that's the deal here. They're gonna dismiss 2 cases and you're gonna plead to 2 cases. Is that right?
Yes.
Anybody threaten you to get you to do that
No.
or promise you anything?
No.
You understand that by pleading to this charge, you'll be giving up your right to have a trial in front of a judge or a jury.
Yes.
If you had a trial, you'd have the right to take a witness stand and testify on your own behalf. But if you didn't wish to, they couldn't use your silence against you. You have a right to have a lawyer with you, and Miss Yancey's been appointed. And you have a right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes.
These might all run together for you, Mr. White. It might be hard to keep them separated.
And Your Honor, in file 25541, that the report I have says March 22nd at McDonald's. I don't have an April 9th report.
All right.
He had an appearance ticket for April 7th from the March 22nd. So I don't know if that's
522 is March 19th.
correct.
541 is April 9th, it says here.
I have March 22nd.
Well, let's look at the actual case. 541. Oops, wrong guy. Yeah, it does say March 22nd at McDonald's. Were you at McDonald's that day and they told you not to come back there?
I'm not sure because I lost the paperwork.
But at some point McDonald's had told you not to come back?
I think so, yes.
All right.
And Your Honor, he was sentenced on Tuesday of this week by Judge Pattison to 17 days in a use of meth and indecent exposure case. So
Yes.
he's serving time on that. We'd ask any jail time be concurrent with that or time served.
All right. $19 days credit, 19 days. minimum allowable fine of $125 or 2 additional days. Concurrent with all else. All right, the other one is that 522? That's 541. All right, let's look at the other case. $522. In that one, it was at Bright and Clean on March 19th. Were you sleeping in there? What, you'd been barred from there too?
Yes.
Now it's rough being a homeless. Have you got any people?
No.
What are you gonna do when you get out? Be back in the soup?
Probably.
Yeah, we don't have a good solution. People, there are a lot of homeless people in Sturgis.
Yes,
And they're camped out in certain places and they're assaulting each other and stealing from each other and sexually assaulting each other and making a mess of things. And they aren't there because they want to be. They're there because they're homeless. Do the same thing, 19 days credit, 19 days, minimum allowable fine of $125 for 2 additional days, concurrent with all other cases. I don't know what your out date is, but this one will be served at the same time as your other ones. So you're good to go, sir.
Thank you. So let's see. So you have about a week left on the case. Okay. About 2, right?
All right, now we'll do Mr. Dante Williams.
And Your Honor, an update to the sheet. He is going to make an admission on a bond violation today, but asking for last pretrial and then underlying misdemeanor.
Okay. Well, I'll have lunch a little late today. A little short. Good morning, sir. Sorry it took so long. We've been working steadily here. All right, this matter is 251626. People versus Deontay Williams. In that case, Mr. Williams is charged with assaulting Ava Mae Calvin on or about August 10th of 2025. The bond conditions were that he was not to have any contact with Ava Calvin or engage in any assaultive or threatening behavior. The allegation was on August 24th. He was at Ava Calvin's, and they found him hiding in the laundry room at Maple Crest. There's also a PPO in place. there is also a new case.
Right, does the record show he's been served with that PPO? This is news to him.
I don't know. Probably nobody's upstairs. The new case alleges that on August 26th, he did a home invasion at Ava Kelvin's house and did assault with intent to do murder by strangulation and a new count of domestic assault. So he got out of jail and he got rearrested on the same thing. So this charge is the August 10th matter. It is, I think, set for an attorney pretrial today, and they set the bond violation. What's our status here, Ms. Harden?
Thank you, Your Honor. We are going to be requesting last pretrial for the underlying charge of domestic violence. I've talked to my client, advised him there's a bond violation hearing set for today. He indicated to me when we met in lockup that he was willing to make an admission as to the bond violation as it pertains to contact. However, I will be mindful of that because of the pending case that has subsequently been filed.
We
So
could do it by no contest.
I would,
Your Honor, if I can assist, the particular bond violation that is currently before the court is not the underlying factual scenario for the new case.
All right.
So it does pertain to his bond, obviously, but it wouldn't necessarily be any statements used against him in the new matter. Although, come time of trial, if that case does go to trial, there may be some other acts evidence that could be utilized. So
This is the laundry room incident?
correct. And my information is that laundry room is on the floor of the apartment of the victim. It's like in her hallway.
Yes. All right.
and Your Honor, I more so was saying that just to kind of advise my client about how much he says so he doesn't delve into the facts of the other case.
Well, why don't we just limit it to that? On that day, Mr. Williams, were you at the complex where Ava lives?
Yes,
And you were in a laundry room outside of her apartment?
I was actually doing laundry though.
All right, did you have contact with her?
No, I did not. She seen me out the window. Well, her mom pulled up to the apartment and seen me in the laundry room. And she said, "You're not supposed to be here." And I said, "I'm just doing laundry. Can you please just calm down?" And then she said, "You need to leave." And I left.
All right. Why did you go there to do your laundry?
Because that's where I lived and before that, and I didn't have the money to go to the laundromat, and like all of my clothes were basically in that vicinity already. I was completely unaware of any PPO or anything like that. And I have not been contacting Ava. She's been contacting me.
All right, well, I don't know about that, but she's not to call you at the jail. We've had this before. There's a PPO or bond condition and the inmate and the complainant are talking on the phone. So she's been contacting.
No, I'm talking about when I was in the free world, and I didn't know that was a thing either. I thought it was just a bond condition that we weren't allowed to have contact if I was on bond.
I do believe there is a PPO. They were concerned because you'd gotten out of jail and this new assaultive case sounds bad.
Yeah, I have
all right, don't say more about it.
The new case? Or
the new case?
I was just talking about the PPO. I was like completely unaware about that. So.
Well, we'll see if we can get a copy of it served on you at the jail.
Do you know who it's against by chance?
I don't have it here. I bet if I call upstairs, there probably isn't anybody there.
Gonna check the ROA real quick, Your Honor, and see if it's in the system.
Okay. All right, thanks. Bye. They're not finding the PPO in the system.
I didn't see one either, Your Honor.
So apparently there is one, so I won't worry about serving it. All right, I'll accept your no contest plea to the bond violation.
Do have a lot going for me in life, so.
Yes?
Yeah, I paid child support for my 3 kids. I pay on my car payment that I'm gonna lose if I sit in here.
Yes, that's all. This new, let's see where the new one is.
It's set for Tuesday, Your Honor, for PCC.
Now, there's another
Even if
one.
I have a tether and just work so I can maintain my
Where
life.
were you working?
International paper.
Well, we'll discuss that.
I don't have any problem abiding by my bond conditions.
So you have another one. Gee whiz, this is 2020. That's on Tara Conklin in Burr Oak. Was charged as a felony.
That was a felony?
Yes.
I thought that was a misdemeanor.
But was resolved as a misdemeanor.
Yeah, I took a plea for that because we were at court for 2 years trying to figure that out during COVID and stuff.
Well, that was an child in common child abuse, 4th degree. Why does that have a FY number?
It's supposed to be non-public.
Yeah, it's public to
Security
me.
clearance.
All right. Well, I'm gonna give you 5 days jail credit. 5 consecutive. To the underlying charge. Means you don't get, you're gonna get 5 extra days.
This case is resolved.
This. So I gotta sit for 5 more days for this case.
After this case is resolved. Yes.
All right, PEC is set for, gonna be real busy next week, 9 on a new assault case. And we'll set the last pretrial on Thursday. So I'm sorry that hopefully they held lunch for you guys, but you're good to go.
Your Honor, if I may, I'm gonna look at the other notes I had. I attended Mr. Williams' arraignment on the new offense. I just want to make sure that there's.
I thought the bond was like $75,000.
60,000.
It's a 60,000 cash or surety, and it does indicate that if he is bonded, pretrial services must tether him before he's released.
All right, that makes good sense.
There's no way it can get reduced.
Well, we can discuss it on Tuesday. The
I can tell you
allegations are
now,
not good.
Your Honor, I'm going to remain on these cases, and I will not be in agreement with any bond reduction from my office's perspective.
Yes, you were on bond for assaulting her. There's an allegation you went over there.
It should be a home invasion and an assault, great
It
bodily
is.
harm and domestic violence, Your Honor.
So,
My family also says she's called you multiple times.
all right, well, that's between them. The charge isn't Ava Calvin versus Deontay Williams. It's the people of state of Michigan versus Deontay Williams. So she can give input, but the final decision is up to them. And I'm of the same mind they were when I was prosecutor. If somebody's on bond on a domestic violence, it gets arrested on a new domestic violence, we treated it very seriously. All right, you can go with a court officer and I'll see you on Tuesday. Bear in mind, they're gonna oppose any bond reduction.
Thank you. Thank you, Your Honor.
That's all, folks. Yep. Been here for 3.5 hours. Actually, a little bit north of that now. Working on 3 hours and 40 minutes. It's all gravy. It's great. Ladies and gentlemen, thank you very much for hanging out with me today. It's been an amazing day full of court. We had a whole hour of sovereign citizens from this past week. Can you even believe it? I can't. There's a lot more that I haven't been able to get cut, so keep an eye out on the channel. I'll have a lot more videos coming out. Check them out. And thank you very much for helping with these videos today. They'll probably come out at some point in time in the future. Maybe you'll enjoy them again. Comment, like, subscribe. For now, kids, I'm signing off. I'm tired. You know how it goes. Where's my thing? Why is... you know, nothing works when you want it to work. I don't understand. Ah, look at that. I figured a thing out. Ladies and gentlemen, you know what we do. You know when we do it. Do what Mama Wolfie says. Come by every night of the week about 9 p.m. Eastern, 8 p.m. Central. We have a live chat where we're talking about the court cases of the day. And I do this little thing every single Saturday starting at 11 a.m. Central Time, noon Eastern. We have brunch and watch court together. But for now, I'm signing off. I'm going to make some more videos. I'm going to have a birthday day. And thank you all very much for hanging out with me on my birthday. It was very special. Chat's been amazing. It's been fun. Rhonda was here. Yes! Oh, and above everything else, thank you very much for Zach, for his donations, and Barry, for his donations today. Those were great. Your contributions, greatly appreciated to the channel. I'm Lone Wolf Oozle. I'll see you next time. Peace out. I mean, it's my birthday. Do you expect a... Do you really expect a Ferris Bueller day off kind of ending on my birthday? Well, of course you do. It's my birthday. That's the type of thing I would do. Now go, have fun. What I'm going to do, my birthday. Time to have fun. Bye.